Okay, Mr. Chairman, we are ready to go.
Ready to go. Good evening and welcome to the February 23rd, 2021 Liquor Board hearing. It is now in session. And as the first order of business, the board now has all meetings transcribed, which serve as minutes of the hearings. The board keeps such minutes stored electronically and they're available to review by calling the board for an appointment.
Mr. Chairman, we are ready to go.
Ready to go.
Oops.
I now make welcome to the motion 23rd, 2021 Liquor Board hearing. It is now in session. And as the first order of business, the board now has all meetings transcribed, which serve as minutes of the hearings.
Mute your mic, Ed.
Okay,
What do you think?
go ahead. We're good.
Okay, so now I make a motion that those transcripts of the previous board hearing held on January 26th, 2021 be accepted as the board minutes for that date, and I ask for a second.
Second, Commissioner
It is
Phil.
seconded. All those in favor say aye.
Aye.
Aye. It's carried. I'll turn the meeting over to Mr. Dales for a couple of announcements.
Thank you, Mr. Chairman. I'm Phil Dales, counsel to the board. At the beginning of every meeting, I make two announcements. First is that the commissioners are part-time public servants. And they have other outside interests besides their service on this board. When they know that they have a conflict of interest or the appearance of a conflict of interest, they will recuse themselves. They cannot possibly know who will appear from the public in any given matter, though, and that may present a conflict of interest to them. If anybody believes that a commissioner has a conflict of interest in any matter tonight, you have to let us know, and when the case is called, and come forward so the commissioner or commissioners can deal with it accordingly. If no one makes any kind of complaint, the commissioners will proceed with all hearings under the supposition that there is no conflict of interest. Second, the rules of the board provide that the chair, for purposes of administrative and judicial economy, can have board counsel, which is me, rule on admissibility of evidence and objections if there are counsel present and objections made. This board handles a multiplicity of cases at every hearing, and this assignment allows us to expedite the hearings. So rather than the chairman turning to me and I advising the chairman, I'll simply make the ruling, and my ruling will be the ruling of the chair. Lastly, this is a COVID-19 hearing. Our rules are published online and anyone can read them. The public can participate, but only by written statements presented to the board prior to the public hearing. Commissioners have read all such statements, read all applications, exhibits submitted with applications, including floor plans and documentation of that nature. The public is invited to listen and look at our hearings. There will be no public personal participation other than by written statements. With that, I'll turn the matter back to our chief inspector, who will call the first case.
Okay. Thank you, Mr. Dales. Before I do, just a reminder to everybody, please announce your name prior to speaking. And this is Chief Wayne Harris. I'm calling the first case, which is Fifth Avenue Liquors, known as 508 Crane Highway Liquors Incorporated. Priyankabin S. Patel, President, Brian D. Lyman, Assistant Secretary, Inspector Earl W. Barnes, Chief Inspector Wayne B. Harris, Sr. This is a Class A beer, wine, and liquor license with Sunday license permits. It's located at 508 South Crane Highway, Glen Burnie, Maryland, 21061. Violation number one is a violation of the rules of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 302, Cooperation. RE Board of License Commissioners, for example, for Anne Arundel County, violation notice was 1502, dated May 5th, 2020. Violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.18, alterations. RE Board of License Commissioners for Anne Arundel County, violation notice number 1502, dated May 5th, 2020. And the third violation is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.05, sanitation and safety. RE Board of License Commissioners for Anne Arundel County, violation notice number 1507, dated November 6th, 2020. This license has a restriction dated 8/22/2017. It says all employees must be certified in a state-approved alcohol awareness training within 90 days. Anyone wishing to testify for or against, please come forward, raise your right hands.
We're actually, Mr. Harris, we're actually waiting for Brian Lyman. Janet is calling him now. He did register, but he is not online at this time. We do have Mr. Burns and Mr. Kellermeyer for the case, but if we could just give a minute to see if he can log on.
Yes, sir, Mr. Aronson.
I'm going to check with Janet.
If he's not there, we could proceed and have Inspector Barnes read the case and then swear in the other licensee when he's arrived.
Yes.
Okay. Did you say you wanted to go ahead and proceed, Mr. Dales?
We should swear those who are here now in, and we can proceed with Inspector Barnes' reading of his report and then swear in any additional licensees when they come forward.
I understand.
Okay, I can go ahead. I'll go ahead and swear you guys in. If you'll please raise your right hand. Do you solemnly declare and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
Okay, we're going to state our names and addresses for the record. I'm Chief Wayne Harris with the Anne Arundel County Liquor Board, 2660 Riva Road, Annapolis, Maryland.
Can you hear me?
Yes, sir.
Earl Barnes, Liquor Inspector, Anne Arundel County, 2660 Riva Road.
Inspector Barnes, could you read your report for this matter, or Chief Harris, if you're reading a report, go ahead and do that.
All right. Before we do, Mr. Dales, I understand Bruce Kellermeyer, who is an inspector for the Anne Arundel County Inspections Bureau, building inspectors, also with us.
I am live.
Providing testimony.
Yes. Bruce, can you hear us?
Yes.
All right. Were you sworn in, Bruce? Did you answer?
Yes.
Okay. I'm sorry, Mr. Dales. Just wanted to make sure.
Okay. All right. So Mr. Kellermeyer was sworn in.
Yes.
Yes.
Could you provide your name and address just for the record and transcript, Mr. Kellermeyer?
My address 27714 Greenwood Road, Denton, Maryland.
Okay, thank you. I think we have your position on the record from Chief Harris's statement. So whether Mr. Barnes or Chief Harris, please go ahead and read your report, please.
You want me to go?
Yes, sir.
Okay. All right. I can't hear myself on this computer. I was back on the 5th of May. I was checking out all my establishments and the goodness and welfare to see how they were doing during the COVID-19 pandemic. When I arrived at Fifth Avenue Liquors, I saw that they had added a building structure onto the end of the building on the south end. I then I entered the building and I was looking, trying to observe or look for a permit. Excuse me, I'm a little nervous. And the whole interior of the business had been redone, and I no notification from the board. I looked for a permit, which I didn't see at first. And after that, I then at that time, it was about 1:45 p.m. I then called Chief Inspector Wayne Harris as a witness and an authority on building codes in Anne Arundel County. While waiting for him to arrive, I saw a building permit from the county for the interior remodel only. Okay, hold on. The interior of the business, Chief Harris arrived about 4:15. and assisted me in proceeding with the investigation of the building. The outside addition was a brick structure on the south end of the building. It was 15 by 2 across, 13 foot on the end, and about 10 foot high. Inside was a completed room that was, the proprietor said, was for building storage of shelving and supplies for the remodeling of the business. Chief Harris and I observed that there was no electrical permit for either the inside or the outside of the structure, and we've seen bare wires around and different things out on the outside. We then called the county inspector, Bill Bryant, to report this incident to the county. We asked, and I asked an employee when this addition was put up, and they had put it up about 2 weeks ago on a weekend in about 6 to 8 hours. Let's see. Okay. So at that time, I wrote them a violation notice of 1502, 3.2, and 4.18. And that's what happened on that particular day. We found no permits at all for the addition and reported it to the county. That was on the 5th of May. Questions? Anybody?
Okay, Chief Harris, are you going to be adding to this report?
Yes, Mr. Dales, I would like to. On November 6th, I asked Inspector Barnes to go back out to Fifth Avenue Liquors. And when he went out there, to please re-inspect and see if any permits were forgotten at that time. I also told him that he would need to write a supplemental report and issue about a written violation for number 1507 for 3.05 sanitation and safety, which actually should have been written the first day and we overlooked it. So it was written on that date, and that was November 6th. We also took photographs, which I believe the commissioners and everyone has of this structure. I apologize for the quality of them, but I think everyone will notice that it was added to the building. And Inspector Bruce Kellermeyer, I believe, was the inspector who was sent out through his supervisor, Mr. Lenny Mathias, and the Assistant Director, Bill Bryant, to follow up on their end.
All right, Inspector Kellermeyer, are you going to be providing additional testimony or report on this matter?
I was sent out to check out the complaint that we received on the July the 4th of 2020. I got there, saw the new structure, took pictures, and went back and filed my report.
All right, so Mr. Aronson, has the licensee arrived?
No, sir, the licensee was not on the premises at any time we were there, either myself or Mr. Barnes.
I'm sorry, Chief Harris, I was just asking as a matter of procedure. I was asking Mr. Aronson if the licensee was here on the call.
Oh, I'm sorry, I apologize.
My mistake. Ed, are you there?
Yes, I'm here. I just spoke to Brian. He is here. He is. I see him now. I'm going to promote him to the panelist.
Let's get him sworn in once he's on.
He's their attorney,
Oh, yeah.
and I believe his client should be with him. There he is.
And Mr. Lyman?
I apologize to the board for delaying the proceedings.
Mr. Lyman, do you possibly have two devices on there?
It
And
should
echo.
be-
Yeah.
Let me check that. I just got the one.
phone maybe? Is somebody's phone dialed in?
You can dial in if you need to.
No, I mean, I apologize. Maybe if I turn my volume down when I'm speaking.
That's good. That's good.
Can you hear me?
Yeah. I think we need to swear in your client.
Okay, if you could raise your right hand.
I've got
If you gentlemen could raise your right hand.
But also appreciate if you pulled our masks down a bit after when it's safe to do so. So
Do you solemnly declare and affirm under the penalty of perjury, the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
If you can state your name and address for the record, please. We can't hear you.
Priyanka Patel, 8704 Tama Drive, Winter, Maryland.
gotta do better.
And I'm Brian Lyman, 703 Robin Hood Hill, Sherwood Forest, Maryland, Lyman. I also have here
Nanlal Gewaria. I'm a civil engineer working on the permit. I live in Ellicott City, 3037 Bethany Lane.
Okay, now, Mr. Lyman, I know you all weren't on the call, but were you able to hear the reports read by the inspectors just a moment ago?
we have reviewed the reports and are willing to admit the violation. I do have, I guess, some questions about the cooperation issue, and I do have a brief presentation to explain the circumstances to the board. And
Yeah, I wanted to give the board members an opportunity to ask questions of the inspectors, then we'll give you your chance to present your case through proper testimony. Do the board members have any questions for the inspectors by the reports? Mr. Chairman, you're muted.
Chairman has no questions.
Commissioner Duffy, Commissioner Filkins?
No questions.
This is Commissioner Duffy. I have no questions.
Okay.
Commissioner Pilkins has no questions either.
It's all yours, Mr. Lyman.
Thank you, Mr. Dale, and thank you, commissioners and staff members and Inspector Barnes, as well as Chief Inspector. I apologize for our technological difficulties here. I was all set up in our conference room, and then we had to retreat to my office, where I think I had two Zoom windows open, which was fixed by Mr. Erickson by deleting one of them out of the meeting.
Not a problem at all, Mr. Lyman. I would say one thing is, I was sort of casual saying it's all yours. I should say, if you have questions about the cooperation issue for the commissioners, and those are questions for for the inspectors, I'd ask those questions first before presenting your case.
Oh, very good. Thank you, Mr. Dales. Mr. Barnes.
Yes.
I understand that the cooperation issue arose with a manager named Brenda. Can you just briefly describe what the issue was with her cooperation with you during the May inspection?
She's most of the time when I've been in there, and she's been there for a number of years, or has been, no longer there, but she was fairly cooperative most of the time, and the last few times of the leading up to this, she was a little bit on the bitter side. I don't know if she was upset about the new ownership or whatever, but for the most part, she was fairly cooperative.
That's fine. I just want to know if there was any specific incident or if she was disrespectful or that there were problems, because she has been let go. There have been certain issues with her employment at the store, and I just wanted to make sure we have a clear record on what her issue was as far as cooperation.
And I understand exactly what you're saying. One of the last times prior to this, she was extremely bitter about something, and I didn't discuss it with her. I wouldn't go there. But for the most part, in the past, she's been fairly cooperative. But the time before this last incident, she was not a happy person. I'll just say that.
Okay, very good. I don't have any further questions for the inspectors.
All right, Mr. Lemon, present your case with testimony or proffer or combination thereof.
Mr. Dales, I'd like to proceed by way of proffer, if that would be okay.
All right.
Essentially here, and I apologize to the board, this is a position I never hoped to be in as a licensee. This is a circumstance where there was miscommunication between the landlord at this property and the new tenant. The tenant had tried to make some improvements and had planned to make some improvements to the interior materials of the store and discussed this matter with the landlord. The landlord ended up hiring a contractor by the name of C&J Custom LLC, who informed the landlord that they would obtain the necessary permits for the work that needed to be done. That was going to be adjusting some of the shelving inside the store, dealing with some of the floor tiles and ceiling tiles. And part of the plan that the landlord and C&J discussed was that they would build a storage area on the one end of the store to store the construction materials during this situation. In retrospect, that was a poor decision. The licensees were not brought into that conversation at the appropriate time when they should have been. The construction actually happened, I believe, just a day or two before this violation actually occurred, which was on the 5th of May. Since this violation, we've had some difficulties in obtaining and determining the necessary permits that we need to appropriately apply for. And that's why I've got the engineer, Mr. Nandlo Gura here, and he's been engaged to take care of all the necessary permits. Apparently, we're in a situation where this isn't a matter of simply getting the appropriate building permits. A site plan is going to have to be prepared in order to perfect this improvement. And apparently the construction is probably not up to code either. Given that, the licensee's plan at this point, and we just discussed it with the landlord this evening, is likely that we will apply for an appropriate demolition permit and demolish the masonry structure that's noted in the reports while we plan for whatever improvements need to happen, and that we will appropriately apply for in front of this board and as well as in the permits department for Anne Arundel County. This is a mistake that is likely going to cost well in excess of the small savings that the landlord had in the first instance with the chosen contractor who did this work without permits. We are guilty. That is an explanation. It is not an excuse. And the licensees acknowledge that there will be a price to pay, and that we would ask the board to consider the fact that there have been some delays in the permit process because of the COVID situation. And the engineer's office actually had a death. The vice president, Mr. Alan Serpin, who was the VP at the engineering firm working on this project and trying to expedite the permit process, was killed in a car accident on October 31st, which further delayed the necessary steps that need to be taken to get this situation straightened out. I'm happy to try to answer questions. My client and co-licensee, I call her Janki Patel, is here in case you have questions. And we do have a representative from the engineer's office in case you want a fuller update on the permit status and process. A permit has been applied for, but ultimately we think probably after tonight's discussion that it's better to demolish what is there and to start fresh. So that is the plan and the presentation. And I thank the board for its time and consideration.
Thank you, Mr. Lyman. Mr. Chairman, do you have any questions for Mr. Lyman or his clients?
Yeah, I do. I'm just a little bit confused. Originally, as I understand it, the inspector saw and found that a structure was built on the end of the building, correct?
That's correct.
Okay, so was anything done with inside that structure as far as shelving and interior work?
No, and I apologize.
Mr. I'm having difficulty hearing you, so.
Let me take my mask down and maybe
Okay.
if you can see my mouth. No alcohol has been stored in this area. It's basically a poured concrete slab and a masonry set of walls. And there is not any storage of alcohol in that shed. The shed was used for storage of construction materials, flooring tiles and ceiling tiles, while the refresh of the premises was going on.
Okay, and then you're saying now moving forward that that structure will be then destroyed.
We need to apply for an appropriate demolition permit. I've got the engineer here. We just discussed that issue tonight, and we believe that's probably going to be the most cost-effective thing going forward, given the problems with the original construction. I don't think there's a proper foundation under the structure, and it's a potential liability.
Okay, thank you. I have no more questions.
Commissioner Pilkins has a question. Why doesn't the county just, can't think of the word I want to use, just deem it a threat and take it down? I mean, you shouldn't have to wait on that. If it's improper and not constructed properly, it's a danger to the community. So I don't see why the delay getting rid of it.
There shouldn't be any delay. The delay was only in dealing with a negotiation between the tenant and the landlord and getting advice from the engineer.
Okay, when this thing started back last November, it's now February. You've been touched 12 weeks or more that you've been dealing with getting rid of this structure?
But the plan to get rid of the structure was just finalized and agreed by both the tenant and the landlord this evening, Mr. Pimpkins, and a permit was applied for to try to perfect the actual building that occurred. We just don't think that that's likely possible, that it will probably not pass final inspection.
Thank you, Mr. Lyman.
This is Commissioner Duffy. And the questions that I have already been answered by, that was asked by the commissioner as well as Commissioner Pittman. And so I don't have any additional questions.
Okay, there are no further questions. Mr. Chairman, I've noticed that Inspector Barnes has been indicating he has something to add. Does the chair or any of the other commissioners want to ask Mr. Barnes what that is?
Pardon me for butting in, but I think the chief inspector had his hand up earlier. I think he probably should be in front of Earl.
Okay.
It's okay.
Thank you. I just wanted to point a couple things out. Mr. Lyman may not be aware of it, but there was alcohol stored in the building. It was not a large quantity. And when I went in there and I pointed it out to him, I was told by the manager on duty at that time, who is no longer there, that that alcohol was being sent back to the distributor, and that's the only reason it was there. I explained to him that he could not have any alcohol at all in that building. And he said he would remove it. They also had a moped stored in there as late as a week and a half ago when we stopped by. And I just wanted to make that part of the record. And I'm not sure if Inspector Barnes wanted to add to that, but and as far as the demolition by the county doesn't do that. Mr. Kellermeyer can explain it in detail, Mr. Pilkins, but what the county does is they tell them to do it. They start with a stop work order and then they give them a final order. And if they don't do what needs to happen, then they, of course, take criminal action, I believe it is. So I don't know if you want to ask Mr. Kellermeyer anything about that. Thank you.
Well, now I'm interested in asking Mr. Kellermeyer about that.
Commissioner Pilkins, I would actually go ahead and do it, just address Mr. Kellermeyer so that he can, for the record, so he can say who he is and then answer your question.
Yeah. Mr. Kellermeyer, shouldn't this building pose a danger to the community? Couldn't it be taken down quickly?
No, sir, it presents no danger to the public. It is secured. There's nothing falling off of it. There's no access, casual entry or anything like that. So the county really has no authority to raise that section of the building. It's solely on the owner of the property.
Very well. Thank you. Thank you, Mr. Kellemer.
You're welcome.
Mr. Chairman, someone want to ask Mr. Barnes what he has to offer?
Yeah.
Go ahead.
Go
Okay.
ahead.
I was just going to reiterate what Chief Inspector Harris said. And that's what we thought from the beginning when we first seen this structure. It was going to be somewhere they were going to be storing alcohol or other products. In the beginning, and the first time we were there in May, it was shelving and stuff in there and this moped. And then all of a sudden, when we got back there, the same thing, you had the moped, you had alcohol stored in there. We never did hear of permission from the board for them to go ahead and apply for the license for this project. And I just want to back up what Chief Inspector Harris said. Thank you very much for your time.
Commissioners, do you have other questions for either the licensee or the inspectors?
I have no questions, Chairman.
This is Commissioner Duffy. I have one question for Chief Harris as well as Inspector Barnes, and that is on your last inspection on November 6th, were there any alcohol that was being stored at that point in time?
Yes, there was. Like I say, it wasn't a large amount, Commissioner, but there was some there. And when I questioned the manager on duty on that day, he explained to me, oh, that's going to be picked up in a couple days. And that's why we have it near the door in this new section. I reminded him that when Inspector Barnes and I were out there, that he was not to store any alcohol at all in that new building. And he said he would remove it.
So prior to that, that was on the 5th of May when you saw it initially?
Yes, sir.
Okay, thank you.
Are there further questions from the commissioners?
I have no additional questions.
Yeah, the chairman has no questions.
Commissioner Wilkins has no further questions.
Hearing no additional questions, we'll conclude the testimonial portion of the hearing and move to deliberation and a decision by the commission. Mr. Chairman.
Yeah, I think it's kind of ironic here that in the last part of that May 5th, 2020, the structure was built in about 6 to 8 hours. I guess haste makes waste. So I'm at this point going to entertain a motion if any of the other commissioners have one with regard to these violations.
Well, Commissioner Pilkins, I find them guilty in all 3 violations.
Do you state that in the form of a motion, Commissioner, or is that just for deliberation?
That was a motion. Now, the question I have is the violations tickets were written, or so these tickets didn't have a price on them like a COVID violation. So that's I would think we should put somewhere around $500 on this thing. So that's my motion, that we find them guilty, $500 for the violations.
For the sake of clarity, Commissioner, are you suggesting $500 for all 3 violations?
Correct, yes.
Is there a second? I'll go ahead and second it.
Okay, the vote is in order.
Yep. All those in favor of the motion, say
Aye.
aye. Aye.
Aye.
All 3 carried. The motion is carried. Thank you.
Thank you, Mr. Lyman.
Okay, thank you, Mr. Lyons. Going to call the next case. Mr. Aronson, will you let me know when we have the witnesses then, please, and I'll go ahead and start reading. All right, the next case is Blas Supermarket and Restaurant, known as Martinez Sanchez Incorporated, Edward Blas Sanchez, President, Secretary, and Treasurer, Colin M. Robertson III is the Assistant Secretary. Leonard Mathias is the Chief Building Inspector for the Anne Arundel County Inspections and Permits. And Michael Williams is previous chief and presently an inspector for the Anne Arundel County Inspections and Permits. The first violation will be violation, excuse me, number 1, violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.02, cooperation, reference Board of License Commissioners for Anne Arundel County, violation notice 2275, letter from Chief Inspector Wayne Harris dated January 7th, 2021, and a final notice from the Department of Inspections and Permits dated October 23rd, 2019. Violation number 2 is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.1A, alterations. Reference Board of License Commissioners for Anne Arundel County, violation notice 2275, letter from the Chief Inspector Wayne Harris dated January 7th, 2021, and final notice from the Department of Inspections and Permits dated October 23rd, 2019. Third violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Section 4.16, illegal conduct, reference Board of License Commissioners for Anne Arundel County, violation notice 2275, a letter from Chief Inspector Wayne Harris dated January 7th, 2021, and a final notice from the Department of Inspections and Permits dated October 23rd, 2019. Violation 4 is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.02, cooperation, reference the Board of License Commissioners for Anne Arundel County, violation notice 2273, supplement report dated January 7th, 2021, and law incident printout dated January 6th, 2021. Number 5 is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.05, sanitation and safety. Reference the Board of License Commissioners for Anne Arundel County, notice 2273. Supplement report dated January 7th, 2021, and a law incident printout dated January 6th, 2021. Violation 6 is a violation of the rules and regulations of the Anne Arundel County, Chapter 3, Section 3.09, public welfare. The Board of License Commissioners for Anne Arundel County, violation notice 2273, a supplement report dated January 7th, 2021, and a law incident printout dated January 6th, 2021. Violation number 7 is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.05, prohibited hours. Reference to a licensed commissioners of Anne Arundel County, violation notice 2273, supplement report dated January 7th, 2021, law incident printout dated January 6th, 2021. The last violation is violation 8, is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.16, illegal conduct. Reference the Board of License Commissioners for Anne Arundel County, violation notice 2273, supplement report dated January 7th, 2021, and a law incident printout dated January 6th, 2021. There were originally 6 Anne Arundel County police officers summoned, Officer S. Silva, Officer E. Trumbauer, Officer P. Hannigan, Officer C. Lyles, Officer J. Foes, and Inspector Earl W. Barnes, and myself, Chief Inspector Wayne B. Harris. This is a Class H license, beer and wine, entertainment and Sunday license, 1701 Crane Highway, Glen Burnie, Maryland, 21061. There are restrictions. They are a maximum of 27 seats. Alcohol can only be served in conjunction with food, and the hours of service are 9 a.m. to 9 p.m. Monday through Saturday, and 10 a.m. to 9 p.m. on Sunday. Beer and wine only. No liquor in any form can be sold. Only entertainment permitted is TVs. And the second restriction is signs must be in English and Spanish to read. Beer and wine cannot be removed from the premises. No carry out beer and wine can be sold Signs are to be approved by the board and posted conspicuously in the case. I'm going to turn this over to Mr. Aronson, who will swear in the witnesses.
Yeah, we have everyone in attendance, so anyone who is going to be part of this case and testify, if you could raise your right hand for me. Do you solemnly declare and affirm under the penalty of perjury, the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
And if you could state your name and address for the record, starting with Mr. Bittner.
Yes, thank you, Deputy Harris. And good evening. I'm Richard Bittner, Bittner, and I represent Eduardo Blas, who's here to my right. He's been sworn on behalf of Blas Supermarket, Trompita Restaurant, Sanchez, Inc. Mr. Chairman, if I may, I had tendered to the board on February the 4th, our notice of our intention to admit the violations that pertain to the incident actually occurring on December the 31st. It's charged as December the 7th, notwithstanding the charging documents defect and the duplicitous nature of it. My client's here and he's admitting it. He's waived the officer. So we're admitting the incident that actually occurred on December the 31st. Your allegation is January the 7th.
Mr. Bittner, with apologies to everyone listening, first, we can't waive the charges, the alleged violations that we had to go through.
Yeah, I didn't waive it.
Understood. And we are going to proceed to have the inspectors read their reports next, and then you'll have an opportunity to ask them questions if you want, or you can admit the charges, but we are still going to have the reading of the reports.
It's your pleasure.
Just to identify myself, I'm sorry, Mr. Bittner, you finished?
Yes.
I'm Chief Wayne Harris, Chief Inspector, Hamilton County Liquor Board, 2660 Riva Road, Annapolis, Maryland.
All right, and so we've had the licensees and council state their name and address. Would anyone else provide testimony also state your name and address?
Yes, if I may, we do have the two chief building inspectors here with us today. Inspector Mike Williams and Lenny Mathias, the present chief. They're here, as well as Inspector Earl Barnes.
Okay, and so Chief Harris, will you be reading the report regarding the alleged violation, or okay, go ahead.
Yes, I will.
I'm sorry, just point of order. So we're proceeding on violation 2273.
Chief Harris, is that the violation for which you're going to read the report? Chief Harris, is that the violation for which you're going to read the report?
Bear with me 1 second. I have several of them, as you know. Yes, I will. This is the one, 2273, Mr. Bittner and Mr. Dales, is the one involving the police department. Did you want me to read that? I can read that, and then I can go into the other report, which is a separate incident under 2275.
I think that's what we should do, is read all of the reports. You can start with one Mr. Bittner just asked about. Let's have the inspectors read all of the reports, and then we'll allow Mr. Bittner to ask me questions if he likes.
Of course. Okay.
If I may, just for the purpose of the records, we had tendered to the board on February the 11th, notice of our intention to admit the sufficiency of the allegations in 2275, the pavilion allegation. So we're conceding the factual basis of that. We do have a legal argument as to whether or not it could be complied with. So however you'd like to proceed, but I want the board to know for your economy that we're not contesting the report.
I understand that. Yep. Thank you, Mr. Bittner. I appreciate it. And we will get to your legal arguments, but Chief Harris, go ahead and read the reports.
Okay, I'm going to read the report dated January 7th. The incident did not occur on January 7th. It occurred on the 31st of December, but the report was written and dated January 7th, 2021. This is Blas Supermarket and Restaurant, also known as La Trompita, at 1701 Crane Highway, Glen Burnie, Maryland. I was the reporting inspector, and the report reads as follows. On December 31st, 2020 at 1:25 p.m., I received an email from the Anne Arundel County Police Department informing me of an incident which occurred at 8 minutes past midnight on that same date. The email reported an incident recording under incident number 2020-358020. The synopsis stated that the officers responded to an alarm call at La Trampita Latin American restaurant. And upon arrival, the officers located approximately 15 to 20 individuals inside drinking and playing cards without masks on. Eduardo Blas Sanchez identified himself as the owner of the restaurant. Sanchez and all the occupants were advised on the emergency order violation. No arrest or citations were issued by the police department. Sanchez was given a verbal warning by the police department at that time. After investigating the circumstances of the incident, and because this inspector had previously had conversations with Mr. Sanchez in which he was explained about COVID-19 rules and regulations and the maximum number of patrons he was allowed to have, as well as the mandatory 10 p.m. Closing. And on the date and time this occurred, that was a mandatory time set by the governor and county executive order. Everyone had to be out by 10 p.m. And due to the degree of importance of violations, I decided to write a citation for the above incident. A copy of the original email and the police incident report is attached, as well as a copy of citation 2273 reflecting the following charges. He was charged with 3.02 cooperation, 3.05 sanitation and safety, 3.09 public welfare, 4.05 prohibited hours, and 4.16 illegal conduct. And if I may, I'll address the cooperation also. Cooperation in this case wasn't Mr. Sanchez not being polite and nice and respectful. He was. The cooperation was the fact that he had been told several times by me alone, and I don't know how many times by Inspector Barnes, about what he needed to do and failed to do it. So therefore, he failed to cooperate with the liquor board and its agents. Requesting a primary police officer handling the case, Charles L. Lyles Jr., and the other officers to be witnessed. And that's where Mr. Bittner had agreed not to bring him in. Citation was written and a copy was left with Mr. Sanchez by it. That's all.
Thank you, Chief Harris. Mr. Bittner, you said that you're going to admit the factual basis of charges, but do you have any questions for Chief Harris?
Yes, if I may, in light of that. Chief, you indicated that Mr. Eduardo Blas Sanchez was polite and cooperative with you, but the nature of the charge of cooperation dealt from your prior admonishments to him to follow COVID rules. Is that my understanding?
It could be construed that way, but yes, basically it was an cumulative thing where after explaining to him and him agreeing to cooperate by obeying the rules and regulations, and then on this particular date, it was obviously he didn't.
And you were counseling him and advising him on the rules when the establishment was open. Is that right?
Yes, that's correct.
And in fact, on this occasion, on December the 31st at 7 minutes after midnight, the establishment was actually closed, was it not?
Closed to the public, yes.
Yes, closed to the public.
Yes.
In fact, law enforcement was drawn to the establishment's attention because an alarm went off.
Correct.
Because Mr. Blas and his family and coworkers were inside having a New Year's Eve party. You aware of that?
Well, I'm not sure if it was a New Year's Eve party or not, but
holiday party.
Yeah, no. Okay.
No public was inside the establishment. It was all employees, family, friends.
That's right. They were inside a commercial business establishment and having whatever you want to call it. But yes, this is a business that is licensed with a liquor license.
After you spoke with Mr. Blass, you didn't have any other issues with him during his regular operating hours. Is that right?
Not on that date or close to that date, but on several occasions, Mr. Blas and I did talk, and we had his son, Oscar, who helped us as a translator, and a young lady, I don't know who she is right offhand, but we did. And in fact, during those earlier conversations, trying to help Mr. Blas, I was referred to your office, and I'm not sure if you remember, but I called you and asked for your cooperation in helping him get his permits.
And that your memory is absolutely correct, Chief. And my point is that in your discussions with Mr. Blass, he always tried to work with you. Is that right?
He said that, yes.
Okay. And you spoke with him, and he didn't have any other incidents during normal operating hours, and then you came to this incident. Is that the state of the record? Just so I understand.
I assume you're not referring to anything prior to that date,
I'm
correct?
talking about the pavilion. I'm just, because
Okay.
as I understand it, as you do, and we thank you for that on the industry side, you try to work with licensees. We'd agree
Yes.
on that.
Absolutely.
And you worked with Mr. Blass, and he followed your instructions, and there were no citations issued until we came to December the 31st, when the establishment was closed. A point.
I think in general, you're correct, Mr. Bittner. At the same time, I did have conversations with Mr. Sanchez and interpreters and tried to make it very clear to him because of the type of business he had, and he had no capacity sign, which the fire department verified that none was issued to that establishment, that he was restricted to a total of 50 people. And that doesn't include the percentages under the different executive orders. And on that particular time, that was a 25% when it was open. That meant he couldn't have more than 12 people in that establishment, including employees at any time. So I tried to make that really clear to Mr. Sanchez and to the interpreters, and they agreed, they understood that.
Thank you.
Okay, Chief Harris, does that include your report for all of the other violations? Did you read all of the reports?
That concludes my report for 2273. We still have 2275, which is a different case altogether.
Okay. Mr. Chairman, do you have questions for Chief Harris?
No questions.
Commissioner Pilkins, Commissioner Duffy?
No questions from Commissioner Pilkins.
Mr. Duffy, you're muted, sir.
No questions from Commissioner Duffy.
All right, hearing no questions, Mr. Bittner, would you like to present your case by way of proffer or testimony from your licensee?
Yes, thank you very much, Mr. Dales. As to the violation of 2273, we indicated to the board the incident of December the 31st. We indicated straight away that my client was not going to contest that violation, notwithstanding deficiencies in the charging documents, because he understands now, and in spite of the chief's very strong efforts, which were followed, because there's been no incidents during operating hours. What happened here? Mr. Blass held a small get-together. He tells me there was about 18 people there. Most blood relatives, a couple employees, a couple social friends, and they were inside celebrating the holidays. The establishment was not open to the public. The lights were off. It was closed. He forgot to turn off the alarm. That's how it came to your attention. But my point, gentlemen, is that this was not an intentional violation. This was not a flaunting of the rules. This is an operator who really, I believe, tries to follow the rules. Often, particularly in COVID-19, are evolving and changing, but he runs a very good establishment, and we know that because since he was granted a license in November of 2012, he's had only one violation. That was just a couple months, 3 months after he took over. And that dealt with, he has a restriction on his license of no service of food, of alcohol without food. That restriction you all have now rescinded. Once the pavilion building permit issue is resolved, you've already granted him permission to expand his hours and expand his operation. So he hasn't had any violations, any technical violations or otherwise. Your inspectors, by my reading of your records, have been out at least 7 times to his restaurant and Colmado, little general store, with no violations. No violations. This was nothing intentional. And that's why, as I want to most strongly reiterate, Mr. Chairman, members of the board, that he comes in here not challenging what happened. And I would ask most respectfully as to violation 2273, that you issue a reprimand, particularly in light of the fact I believe summonses were issued to these officers, so he's probably going to get assessed the cost, which are going to be substantial with a half a dozen officers. I mean, he really did try to ameliorate any inconvenience to them and the board. Thank you.
Mr. Bittner. Mr. Chairman, you have questions for Mr. Bittner?
I have no questions.
Commissioner Duffy, Commissioner Pilkins, do you have questions for Mr. Bittner?
Commissioner Pilkins, a comment. You said that the building was not open to the public. I don't think the law specifies it that way. There were people in the building and people were partaking of food and beverage in the building. This was a COVID situation. The problem doesn't go away because you can't call them, it's not open to the public. That's the view I'm taking on it right now.
And we respect that view and appreciate that view. And you're right. My only point, Commissioner Pilkins, is that it's a violation. That's why he's admitting it. But in the scheme of things, we'd ask the board to consider that he wasn't open to the public. He had intimate family members and friends at a holiday party. And I think that is a distinction that the board should consider. Thank you.
My comment was only meant as a clarification.
Commissioner Duffy?
No, I don't have any questions.
Okay, if the chairman and commissioners do not have questions, additional questions for the inspectors, then we would close the testimonial portion of the hearing and move to deliberation and a decision by the board.
Yeah, our overall, this is this is the chairman. The violations of the COVID rules were set out pretty much by the governor and the county executive, and the first offense was $500. And many a restaurant licensee were charged for that violation. So with that having said, I'm going to move at this point that we charge Ross's supermarket $100. And I look for a second, and including court costs. Seeing no second, I can't open it up for discussion further. I'll withdraw my motion. Is there any motion out there with regard to the violation in question?
This is Commissioner Duffy. Based upon the licensee being briefed earlier and to being advised about the closing time as well as the executive order, I feel and would like to make a motion that the license need be assessed a fine of $400 plus cold calls because of the number of times that he was advised about the county executive order, as well as the hours considering closing time at 10 o'clock, regardless as to what the circumstance might have been.
Okay,
I'll,
there's,
I'll second the motion.
the motion is second. Any further discussion on this? All those in favor, say aye.
Aye.
Aye. The motion is carried. Thank you.
Thank you.
Harris, would you call the next case?
Okay, this is the second charge for the same establishment. I've already read all the charges, so would you want me to proceed with the report?
Yes, please.
Okay, thank you. Report was dated January 7th, 2021 for Blas Supermarket and Restaurant La Trompita at 1701 Crane Highway, Glen Burnie, Maryland, violations of local building codes and regulations. On the above date, January 7th, this inspector met with Mr. Eduardo Blas Sanchez, the owner and operator of the above named establishment. One of the purposes of visiting this establishment was to deliver a written violation number 2275 for violating on more than one occasion the rules and regulations pertaining to illegal alterations of buildings on the property located at 1701 Crane Highway, Glen Burnie, Maryland, on or about June 25th of that year, 2020. This inspector was traveling south on Crane Highway and I noticed a large wooden structure. It's more like a commercial pavilion that had been erected on the property of the above business. I also noticed a large canvas tent of a commercial grade over 200 square feet was erected right alongside of the wooden structure in the same area. As chief inspector, I was not aware of any of the permitted alterations coming across my desk or anything that the liquor board administration brought to my attention. Even during the governor's proclamation period, and knew that both would have to require at least building permits. I stopped in, and after speaking to the owner and operator, Mr. Eduardo Blas Sanchez, and his son Oscar, who acted as an interpreter, I confirmed that neither had building permits issued. I also noticed during my visit that there was construction going on in a portion of the restaurant area where walls were being changed, as well as the other physical changes that would require a separate building permit. When questioned about that, Mr. Sanchez said that his attorney, Mr. Richard Bittner, was taking care of the permits. I then informed Mr. Sanchez and his son Oscar that I would speak to his attorney and see what the status was on the permits. During my visit, I took photos and they are attached. In the photos, if you have them in your file, and you should, will show both the wooden pavilion and the large tent, which is definitely well over 200 square feet. There at that time, both the tables and chairs were in or under reflecting daily use. Mr. Sanchez admitted to this inspector that he would stop the use. It wasn't a lot of tables, but both the tent and the pavilion had tables and chairs. It seemed that the wooden pavilion was trying to service a food trailer that was parked also on the property there. Anyway, this inspector did contact Mr. Bittner and informed him as to my visit, and he agreed to look into the matter and make sure all the required permits were being pulled. After checking with the Inspections and Permits Division, I discovered that no permits at that time had been applied for either structure. I requested to be informed if any of them did, and Mr. Bryan said that he would see that that happened. Mr. Bryan, Bill Bryan, was, I believe, Assistant Director of Inspections and Permits at that time. I immediately notified, I'm sorry. I lost my place. Yeah. Oh, when I did stop by in August and I noticed a large and a number of vehicles on the parking lot and a few people standing under the canvas tent. When I entered the building, I went and met with Mr. Sanchez. I immediately noticed many patrons in the restaurant and reminded him of the county executive order, which limited capacity, and that was on that date, to 25% of its full capacity. Now, remember, I testified earlier that there was no capacity sign issued by the fire marshal's office, and that would automatically limit the capacity to 50 people, no more than 50 people. I asked to see the capacity sign that the fire marshal's office had given to them. I was told Mr. Sanchez and a young lady who was acting as an interpreter that I would check with the fire marshal's office and get back to them. And I did check with the fire marshal's office. I discovered that Mr. Sanchez was correct in stating none had been issued to the establishment. But I also informed him because of that, his total capacity is automatically limited to no more than 50 people, as capacity signs are issued to establishments that would have more than 50. As I promised, I called the establishment and spoke to Mr. Sanchez's son, Oscar, and informed him that he was not required to have a capacity sign, but I also informed him that he was not allowed to exceed a maximum capacity of 50 during any time, and that did not include any restrictions under county executive and the governor's proclamations and executive orders. I also reminded him that under the present status of the county executive's orders, he was only permitted at that time 25% of the maximum, which would allow him no more than 12, give or take, or 13 at any time, including employees. He said he understood and would pass that information on to his father. I also told him I was not citing them for the violation, but he should consider it a warning. I was told by the county health department officer who had stopped by there at a later date that when he stopped by, he took notice and called for inspections and permits to investigate something. And I believe Inspector Mike Williams was the inspector who went out on that day. But because of that visit, I became aware of the visit and was informed that inspections and permits were looking into a previous stop work order, which was not satisfied, and that because of the tent and the wood structure, the permits would not be issued because of the failure to obey the letters on a previous violation. After speaking to Mike Williams, who was the building inspector of record for earlier violations in a stop work order, I discovered that a final notice letter was issued on October 23rd, 2019, and it was never addressed. I was told that no action had been taken to satisfy what was required by that letter. Also resulted in no further permits being issued because that final notice was not satisfied. The final notice had a required action to be taken no later than November 26th of 2019, but no action was noted. I have attached a copy of the final notice from the inspections and permits of Anne Arundel County. That final notice was written by Chief Inspector Mike Williams on that date and was also the same inspector who investigated the status of the standing of the non-issued permits for the two outside structures. I asked Inspector Williams if the governor's and the county executive orders may have influenced the issuance of the permit, and he stated not that the issuance, but would take time. But perhaps the time it would take to get the permit. But most of the delays appeared to have been non-responses from the establishment, not a COVID situation. It should be noted that while researching the folder for drawings and letters from permission from the board, I noticed that a letter from Mr. Bittner's office, which stated that the floor plan would remain as is and in the current layout, but in fact had been altered by adding a wall and closing in a counter and deleting a display area and not installing items per the submitted drawings. When asked about this, Mr. Sanchez said he was just trying to improve the drawing and that things had to change once he moved the groceries in. They'd go downstairs and the entire floor would become a grocery store upstairs. This inspector issued order number 2275 for the following charges: 3.02 cooperation, 4.18 alterations, and 4.16 illegal. And again, the cooperation was not that he did not personally cooperate, but the fact that he didn't cooperate with the rules and regulations of the liquor board. And I attached two or three photos of the tents and the structure. That's all.
Thank you, Chief Harris. Ms. Bittner, question for Chief Harris on his report.
I have a question. I'm going to move to strike the extemporaneous testimony that doesn't apply to the allegation of January the 7th, 2021, which is what I understand based on the charging document that we're here for. And I'm going to submit and just ask to be heard.
Mr. Bittner, in order to rule on that motion to strike, I have to know exactly what you're referring to. What testimony are you referring to if you're asking us to strike?
Everything that didn't touch on January the 7th. We heard a lot of testimony about capacity signs and prior visits and hearsay from this inspector. My client is here, we believe, because he hasn't yet secured the proper building permit for a wooden pavilion that hasn't been in use. So that's what I thought we were here for based on the charging.
If you're asking us to strike something from the record and you're saying it's hearsay, then specify what that is, and I'll consider what it's hearsay and whether it should be struck. If you're asking us to strike something from the record as irrelevant, then tell me what that is, and I'll consider it and make a rule.
Most respectfully, I'm not going to belabor the point and take up the board's time. I'm going to just submit. I'm going to make my motion and submit.
Mr. Chairman, do you have questions for Chief Harris?
I have no questions.
Commissioner Pilkins, do you have questions for Chief Harris? Mr. Duffy?
Commissioner Pilkins has a question. Does Mike Williams have any need to testify on this? He's here, and I'm wondering if he can add to any of the testimony.
Commissioner Pilkins, do you have, or Mr. Chairman, would you like to hear testimony from Mr. Williams?
Yes, I would.
Mr. Williams, do you have a report to read on this matter, or are you just going to provide firsthand knowledge of the incident?
Repeat that, please.
Mr. Williams, do you have a report to read regarding this matter, or do you just have testimony, firsthand knowledge of the incident?
I just have testimony, the letters that we have sent.
Okay, Commissioner Pilkins, did you ask for a specific, you're muted.
No, he's here, and I just want to be sure that if there's issues with the chief's statements, that Mr. Williams could either back up some of that or add some depth to it. Just offering. He's here, and I thought he should be asked, or if the chief thought maybe he might be able to assist in rounding this thing off.
Commissioner Pilkins, I think if you wanted to ask Mr. Williams for information that he has about this matter, then you should just ask him that and let him.
I was asking the other commissioners as well as Mr. Williams and the chief, rather than going directly with Mr. Williams. That would have been more proper, I suppose, but the question's out there. Is his testimony valid, or do we need to hear it? And I'll ask that of the chairman or chief inspector.
If I may, again, I had both Chief Inspector Mike Williams and Chief Inspector Lenny Matthias summons because they did have some relevant information and could verify and confirm whether it be the dates or the actions on behalf of the inspections of the building inspectors and inspections and permits. And I think it might be relevant if you want to at least, if you think it's relevant, to at least ask Inspector Williams and Inspector Matthias if they have anything they want to add or let you know about.
Mr. Williams, Mr. Matthias, I would enjoy hearing anything that you can say that to add to the testimony. That would be helpful to me.
Okay, we received a complaint in our office about some construction of a tenant space. And we sent Leonard Mathesius out there.
I'm sorry, Chuck, the inspector appears to be reading from something. I just want to make sure that I've been provided a copy of what he's reading for. Can you identify what he's reading, please?
Mr. Williams, are you reading from something? Is it just your prepared remarks, or is this from a report, some sort of evidence?
I've got notes on the subpoena. Got notes on the subpoena that I was sent.
Mr. Bittner, I believe that Mr. Williams is just reading from notes for his testimony.
Okay, so he needs these notes to refresh his recollection then?
Mr. Williams, do you want to read? You don't have to read directly from what you've got there, but if you want to speak about your firsthand knowledge of this matter, then I would encourage you to do that.
Okay. We had a complaint registered for this address. We sent Mr. Mathesius out there. He investigated some work being done in the lower level. We've sent them a first letter giving them 30 days to apply and acquire a building permit for that work. They did apply for that permit. It is being held by the health department. All the other agencies signed off on it except for the health department, which the health department sent them a comment letter from the permit office on February 13th, 2020 for their requirements to issue this permit. They applied for a tent permit, which the inspector referred to, that's out front of membrane structure. That has been gone through the approvals, but it is being held because of the first violation. If there's a violation on the property, until that violation is solved, they will not issue other permits. So that's where we're at with this.
That would be correct.
Thank you, Mr. Williams.
Are there other questions? Mr. Bittner, do you have any questions for Mr. Williams?
Yes, thank you. Inspector, so if I understand what's holding up the tent and other building permits is the pavilion permit, the pavilion, is that it?
No, sir. The first violation is a permit that reads to move the grocery store to the lower level. That permit is the one that is being held by the health department. It was applied when we sent them the letter, when Mr. Mathesius did the violation, we sent them the first notice. They complied, they applied for the permit, and it's gone through its reviews, but the health department has it flagged for requirements that they've asked for. And so that is what's holding that permit from being issued. And until that permit is issued, other permits that are applied for cannot be issued because of the violation in the system.
So you couch it as a violation, but the establishment hasn't been charged with a violation. If I understand your testimony, they're holding the permit. The health department is holding the permit till he meets certain requirements that they requested of him.
We actually sent a violation letters for that basement work.
Okay.
So that is a violation. It is in our complaint system. So that's why other permits cannot be issued.
Okay, well, I thank you for that, because I tell you, kid, I was not aware of that. So I'm glad that.
Right. I mean, they did.
Let's ask you the question.
When the tent surfaced, they did apply for a permit, but it's in the system, but it cannot be issued because of the prior violation.
Now, I believe let me retract that. So, Inspector, Mr. Blass needs to resolve the lower level permits in the health department before the county will give him his tent permit, which has been applied for and approved, and the pavilion permit, which we'll talk about in a minute.
That is correct in referencing the tent. I did not see anything in the system where anything has been applied for the other structure.
I'll get to that in a minute. I think the architect sent that in yesterday, the day before. Now let me ask you this, sir. Mr. Blass has indicated to the board that he does not intend to go forward with the repair, with the alterations, the renovations to the basement. That's in the liquor board's file. So if he doesn't intend to go forward with those renovations, he would need to notice your agency so that they can withdraw their violation.
He would have,
right?
he would have to do that in writing, but I think I was not the one that investigated the work. Mr. Mathesius was, so he would have to answer that question, what work was done, that we would have to have a permit to cover that work. So.
Thank you. ¿Entiendes? Okay, go speak.
Is that it, Mr. Bittner?
Yes, thank you.
All right. Commissioners, have any other questions for the licensee or for the inspectors?
Commissioner Pilkins again, a question. What's going on in the basement? Is there any business going on, storage down there? Is it being used properly or is it not? I'm a little confused why we've done this work and we can't get the health department to approve it. And I'm not sure we want to delve into why at this point, but I'm wondering what's going on in the basement. If now they're saying they're not going to use it, are they currently using it for anything?
Leonard Mathesius here, Chief Building Inspector. Last time I visited the property, I took many pictures of the downstairs. It is completely renovated. It's ready to go. I wrote the violation on 4/10 of 19. I gave them till 5/11/19 to respond. I spoke to the architect or engineer at several times on the phone, what he had to do to make this happen. Finally, on 2/7 of 20, the application was applied for and it has never been sought after since. So actually it was applied for February 7th of 20, and it's been sitting idle, waiting for comments to come back from the architect or engineer on site. Some of the other trade inspections, there were 6 other trade inspection permits pulled, all which some of them had some inspections done. 5 out of the 6 current permits on the property are expired now from inactivity on the property. There's only one remaining one that is not expired, and that would be a mechanical permit for replacing a furnace. That was just pulled on February 17th of 21.
Thank you. That's interesting.
Questions from the other commissioners?
If the chairman has no questions.
Yes, Commissioner Duffy, I have no question.
Thank you.
Richard Bittner, no questions.
All right. So I guess we'll close the testimonial portion of the hearing and move to deliberation and decision by the board.
If I may be heard in argument.
Mr. Bittner, I thought you had submitted. I apologize. George, if you want to present your case or proffer or testimony.
Yes, thank you. Initially, we filed this yesterday at 1:55 p.m. a request to submit documents out of time. I'd ask initially, is the board going to receive those documents? Because I'd like to argue from them. I believe we've shown good cause for the late submission in that the architect who's been discussed here tonight just provided them to us on February the 20th, Sunday. So does the board have those documents? Are they admitted?
Yeah. I don't have the documents. So this is the chairman.
Mr. Chairman, what was that you said?
I'm just saying I don't have a copy of those documents.
Mr. Aronson, can you unmute your mic? Mr. Aronson.
Yeah, what documents are we talking about?
Mr. Bittner, could you clarify?
Certainly. So we filed, we sent a copy to council as well as to the board, February the 22nd at 1:55 p.m. They consisted of two exhibits. Exhibit A was
Right, yeah, we did receive those. Those were after the 5 days for exhibits and public testimony. They were sent to the board and I guess they decided not to put them in the record at this time.
Mr. Bittner, I thought that's what you were referring to. Those were received after the cutoff from the board's rules, so are not part of the record. But you can proceed with your case.
well, let me make my record then, most respectfully. The documents, you're absolutely correct, were filed late. They were received late. The rule, as I understand it, allows the board, upon a showing of good cause, to waive any late filing. So that's why specifically we filed a request to admit the documents as soon as we received them, and we laid out why we were filing them late, because we had just received them. Most respectfully, these documents are material and salient to the case and to the disposition of the case. The rule of filing is, most respectfully, a rule of inclusion, not a rule of exclusion.
Mr. Bittner, I'll tell you, the rule exists for the purposes of our efficiency and economy of our resources for these virtual hearings. This is not the rule on application materials. This is the rule on evidence for the COVID virtual hearings. And you're right that the board does have the ability to waive the rule and accept the evidence. You've presented some reasons why you'd like them to waive that rule. Mr. Chairman and members of the board, would you like to allow Mr. Bittner to enter those documents into the record based on his arguments, or would you not like to let him enter those documents?
The reason I didn't get those, I got the documents late yesterday, but couldn't print them. That's why I basically didn't get a chance to review them. So at this point, I'd say no.
All right. Mr. Bittner, you can proceed with your case and make your record, I should say.
Well, I just made my record. I don't have anything to say. You just excluded all of the salient, most important documents that show my client's efforts to obtain a building permit and the dilatory actions of the architect that have now befallen him. So,
well, Mr. Bittner, respectfully proceed with proffer, or you can ask your licensee for testimony. But I apologize. I asked the chairman whether he'd like to include, allow you to introduce those exhibits. But Mr. Chairman, would you like to put that to the board, or just make a decision of yourself?
No, I'd put it out to the board.
Okay. Commissioners, would you like to discuss and vote on whether or not you'd like to accept the exhibits?
Commissioner Pilkins will jump right out and say there's an enormous amount of paperwork on this, and we have others as well. Our time is limited, and I wouldn't have had time to review them coming in this late. I really wouldn't.
That is the other purpose of the rule. So, Mr. Bittner, while you have a good reason, it sounds as though the board, two of the board members have said that they don't favor allowing the evidence to be entered into the record, but you could proceed by proffer.
certainly, I understand the board's ruling. So I would proffer to you, though, not in evidence, I would proffer to you that as you've heard from the chief inspector and the building inspectors, this has been, these permits have been an issue that have unfortunately and sadly been ongoing. You heard that, and again, I thought the charging document said we were here for the pavilion. But in any event, the genesis of this problem is Mr. Blass's attempt to renovate his establishment that's been held up by the health department. Because of that hold, Mr. Blass noticed to the board that he was not going to proceed with the renovations, though he did wish to have the privileges. The board advised him that he had to sort out the pavilion issue before he could have a new license picked up with his new hours. He indicated to the board he wasn't going forward with the renovation, so to the interior, so that stopped. Been no work there, it's not occupied, it's not used. COVID strikes. He tries to avail himself of the tent provisions, and Chief Inspector is absolutely correct. It was with his assistance that he provided us the necessary forms and allowed Mr. Blast to apply, and that was approved, not granted because of the basement, which he's not using and has indicated he's not going to use. The pavilion was constructed without permits. We conceded that. We sent a letter, we admitted we conceded this, waived the inspector's presence for board economy. He's been waiting on the architect. You've heard from the testimony, the difficulty with the architect. And on February the 19th, the architect sent me an email with what appear to be the necessary schematics, drawings, plans to apply for the renovations inside. He detailed all of those in the email of February the 19th, which we submitted but hasn't been admitted. He made reference that the pavilion permit was going to be applied for in 2 to 3 weeks. I queried him again about the documentation supporting that allegation, and he provided to me on February the 20th, an email along with 3 pages of architectural drawings referencing the pavilion. So my point, gentlemen, most respectfully, is that Mr. Blass is doing everything he can. The pavilion has not been in use. It's not in use. The basement, which I don't believe is subject to this proceeding, but is not in use. The tent, I believe until this moment, he understood he could use the tent, but I'll make sure that it's not in use going forward. Again, we have an operator, a small operator who's trying to deal with a labyrinth of permits with a government that's closed down some days, opened up other days. The architect has finally given us the documents. The architect says the permits have been applied for. What I would ask the board most respectfully, particularly in light of information that we've received right now about having to correct the issue in the basement to get these other permits straightened out, that the board hold any decision in this case. I'd ask that you hold it for a period of 60 days, allow this permit issue to clarify, perhaps allow the board an opportunity to review these documents, which again, I think are material to any decision that the board would have to make. And that's why we submitted them as soon as we got them. And we submitted them with a petition asking you to consider them. We just didn't send them in cold without any identification. So I'd ask most respectfully that you hold this matter sub curia, review those documents, allow me an opportunity to follow up with the inspectors regarding this basement issue, and deal with it at your next hearing. Thank you.
Thank you, Mr. Bittner. Mr. Chairman, Commissioners, do you have questions for Mr. Bittner?
The chair does not have a question.
Mr. Commissioner Duffy, I have no questions.
Well, Commissioner Pilkins is going to ask a question. All that needs to be done is the health department violation be taken care of. That's what I'm hearing here, and then everything moves forward. So I guess that's the only thing that has to happen at this point. Am I correct about that? That is, what else is stopping it? Even though the owner says he's not going to use the basement, but it's completely built out now. So all the health department has to do is come to terms with the owner and get that resolved. And then we can talk about what we started talking about earlier in this. Just a comment, I'm perplexed about this complexity.
Okay,
Because I believe you're correct.
Okay, Mr. Bittner, I was going to say that wasn't really a question, but if you wanted to respond to it, I think you have the opportunity.
Thank you, Mr. Dales. As I said, I believe the commissioner has squarely hit the nail on the head as to what the issue is here. And I can tell you, and it's the chief knows, I've been trying to work with Mr. Glass First, I learned of that. First, I understood it. So perhaps I share some of it. But I would ask again, I would renew it, particularly in light of the commissioner's comments, that this matter be held sub curia, and give Mr. Blass an opportunity to sort this paperwork out, particularly in light that we now have apparently the architectural documents that we need.
Okay, thank you, Mr. Bittner. So I think we'll now close the testimonial portion of this hearing and move to deliberation and debate. And I would begin by telling the chairman that if the board wished to grant Mr. Bittner's request, that I would propose that the motion be a motion to continue the hearing on this violation until our next meeting. And that's how I would phrase the motion. If that's something the board wants to entertain, the board wants to rule on this violation, then by all means do that and make an appropriate motion, and I'll get out of the way for you all to deliberate now.
Thank you. Where do you begin? I'm going to turn it over to the commissioners if they have a thought or a comment to make prior to our any decision we make, either extending this to the next hearing or to assign they pleaded guilty, so we assign a fine perhaps.
This is Commissioner Duffy. Based upon the information that's been provided and in light of everything that's been discussed, I'm in favor of extending this hearing until the next hearing next month, based upon the fact that we now know exactly what has caused the delay in reference to the health department. And although individuals have stated and it's been verified that individuals, the owners, haven't responded to all necessary letters that has been forwarded to them. But now we understand that one of the major holdup in this particular case is that of the health department. And so based upon that, I would like to see this held over until the next month. If I can, that's not in the form of a motion, that's just for
Just a comment. Okay, thank you for the comment.
Commissioner Pilkins has a comment too. Thank you, Commissioner Duffy. I guess I can be convinced to move it to the next meeting. However, that would be predicated upon the health department requirement being met and the violation cleared there. If that doesn't happen, then I'm not interested in hearing any more of this.
Yeah.
What we're losing the sight of here is if he's not going to use the basement, but it's completely done now, except for the violation, then the only way you can get me is to take the whole thing out again, tear it out, make it a basement again. But I'm just worried that we're going to end up with more violations because people either don't understand the system or they're having contractors that don't understand the system. We've been talking about this for an hour or more now, and it's just a waste of time. So if in fact we hear it next month, the health, this is my opinion, the health department violation has to be cleared. And then we'll hear the meeting, we'll hear the violation. So again, so that's my thoughts, and it's not a motion. So.
Yeah.
Well, certainly my comments would include that all documentation be submitted to this board for approval prior to moving forward with anything. So that would include all violations, to include that of the health department. That everything would have to go back through the liquor board commission in order for anything to be resolved. So I thoroughly agree.
Okay, it is kind of interesting that the whole basement is finished. And apparently we're just waiting for the blessing of the health department. So it's a violation, so to speak, but probably not unless they go in and inspect it. We also noticed that many of the permits that are there have already expired. So there's going to be a lot of reapplying, I would think there. It just doesn't seem to be have any particular way we're going here. So totally at a loss, other than your comments, gentlemen. I would be willing to have them extend, and I'll make a motion to that. We'll extend this hearing till the next hearing so that we can get a better look and see where we are. And if we have a second, that would be great.
This is Commissioner Duffy. I second the motion.
Okay, those in favor, say aye.
Aye.
Aye. Any opposition?
Commissioner Pilkins is opposed.
Opposed? Okay, it's carried. Thank you.
Gentlemen, is that March the 6th or the
March the 9th,
March?
2 weeks from tonight, 6 p.m.
I had asked for, most respect, yeah, thank you for that, but I'd asked for 30 days. Could we have the next date? I mean, 2 weeks. I think Commissioner Pilkins is probably right. In 2 weeks, we're not going to get anything. I mean, if we could have a realistic, perhaps.
Glad you
Chairman, we could make the motion for that a longer continuance. However, I think you should deliberate as to what the purpose of your continuance was. If it was just to allow reading of the evidence that Mr. Bittner had submitted, that's one thing. If the other discussion is the reason for, the part of the reason for the continuance, you may want to discuss that and then decide whether you wish to make an additional motion. Mr. Chairman, can't hear you.
I'm sorry, I couldn't.
Why don't we, can we withdraw that motion since it's been voted on? Can we do that?
You just have to make an additional motion to further continue the case to continue to a different date.
But we're still not going to add the fact that the health department violation has to be cleared first before we hear it. That's where I'm driving to, I guess.
The motion, Mr. Chairman, to be clear, was to continue the case to the next hearing, to continue the violation hearing until the next hearing of the board, correct?
Correct.
So I think if we want to continue it to a different meeting than our next meeting, the motion either needs to be amended or an additional motion needs to be made to clarify that and then continue it to that subsequent meeting. However, I think that you all should be clear as to your reasons for doing that and decide whether or not you want to grant that request. So I feel you should deliberate, given that the hearing is coming up very soon, and you did discuss some things that would be affected by that short time between now and that next hearing. You should discuss whether you want to make an additional motion or not. I think it merits some deliberation between the board members.
Well, how much time are you looking at?
When's the next hearing, Mr. Aronson?
The next hearing after March 9th would be April 13th.
So the motion would be to continue to April 13th if you were so inclined.
Yeah.
And we don't have a hearing in the month of May because of renewals. So that would be the last hearing available, April 13th.
I would be inclined to extend it to the April 13th hearing.
I think we need a motion to do that.
Okay. I just so moved that. I'm moving that we're extending this session, this hearing, the Laws Supermarket to April the 13th. And do we have a second?
This is Commissioner Duffy. I'll second the motion.
Okay, those in favor say aye. Aye.
Aye.
Opposed?
Mr. Pilkins, you're muted.
Sorry. Commissioner Pilkins opposes it.
Okay. It's carried. Thank you.
And thank you, Mr. Bittner, for pointing that out.
Thank you, gentlemen.
Chief Harris? You're on mute, sir. Chief Harris, you're still on mute, sorry.
I'm sorry. This is Chief Harris. The next case to be called is Brick House of Shady Side. All the witnesses are excused. Thank you very much. The Brick House of Shady Side, also known as Litchfield Day Incorporated, Joseph Peter Litchfield. This is a non-restricted license. They're looking for a change of officer. Currently, Michael D. Jones is the president and director on behalf of Litchfield Day Incorporated, trading as Brick House of Shady Side, 1534 Cedarhurst Road, Shady Side, Maryland, 20764. Class B license, beer, wine, and liquor, dancing and Sunday license. Anyone wishing to testify, please step forward, raise your right hand. Mr. Litchfield, can you hear me?
Yes.
Raise your right hand, sir.
Oh,
We'll
I'm
swear
sorry.
you in. That's okay. All right. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, please state your name and address for the record, Mr. Litchfield.
My name is Joseph Litchfield, 1534 Cedarhurst Road, Shady Side, Maryland.
Thank you, sir.
Do I need something else?
Do we have others who are providing testimony? They need to state their name and position for the record, or are they already?
No, it's just Mr. Litchfield.
Okay. All right. Chief Harris? Is there a report?
This is for a change of officer.
Oh, this is application. We'll move to that portion of the hearing. All right.
You're
So, it's just the applicant then, Mr. Litchfield. You're free to present your case for the by proffer or testimony for the license change.
You want me to say something?
Yes, you're free to present your case through proffer or testimony or a combination.
Okay. The reason that Mr. Jones was on the license is because the girl that had worked for me for several years, and I want to say that the Brick House has been in business in Anne Arundel County for 22 years without any problems. And Mr. Jones, who was not only my partner, he was my best friend. He died suddenly last January. This has been a very long ordeal for me and very expensive. And so since I was not allowed to be on an officer of the corporation because we had gotten into another venture, which I am completely out of now, there was no one to transfer the license to. And since his son, his heir, did not meet the requirements or the criteria set forth by the Board of License Commission, then this is why we're going through so much right now. So I've given all the paperwork. I've had the lawyer. And so we have submitted in the death certificate and all the affidavits that they'd asked for. And I believe we've done everything that we're supposed to. And I believe that this should be, you should grant it to me. I'm completely divested of everything else. And I've been working pretty hard here for a long time and serving this community. I'd also like to point out that it's almost always food, almost all food. And our median age here of the patrons is about 55. That's median. I mean, I just would like to go on as long as I can in a very tough time. Is there anything else I should say?
Thank you, Mr. Litchfield. Mr. Chairman, do you have questions for the applicant?
Nope. No questions.
Other commissioners, questions for the applicant?
This is Commissioner Duffy. I have no questions.
Did we lose somebody?
The other.
Yeah, it looks like we lost Mr. Pilkins.
All right, well, we still got a quorum. So we'll continue and hope that he'll rejoin the call. And Mr. Aronson, if we were able to, looks like.
Here he comes.
Okay.
Okay.
All right, Mr. Pilkins, questions for the applicant? You're on mute.
Commissioner Pilkins I heard all the testimony. It was just my video that went away.
Okay, any questions for the applicant?
No, I have no questions.
All right, then we'll conclude the testimonial portion of the hearing and move to deliberation and decision by the board.
I move we grant the change of officer.
Second, Commissioner Pilkins.
Okay, all those in favor, say aye.
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 Aye. The motion is carried. Thank you.
Thank you.
Thank you, Mr. Litchfield. The next case is Lee's
Thanks, Judy.
Szechuan Restaurant, known as S&H Asian Cuisine Incorporated, Quinn Hung, President and Secretary. This is a non-restricted, well, I'm sorry, it has one restriction. Alcohol beverage must be served in conjunction with meals. This is a transfer. It's currently in Juan Chin, President on behalf of Plum House 2, Incorporated, trading as Lee's Szechuan Restaurant, 672 Old Mill Road, Millersville, Maryland, 21108. It's a Class H licensed beer, wine, and liquor with Sunday privileges. Anyone wishing to testify for and against, please raise your right hand.
Right hand.
Thank you. Do you have your hand? Okay. All right. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Yes? Okay. Please state your name and addresses for the record.
My name is Quinn Huang, and this is 25 Whites Road, Serrano Park, Maryland, 21146.
Thank you.
Thanks.
All right, Ms. Carter, represent the applicant's case through testimony or proffer or combination thereof.
Good evening, Mr. Chairman, members of the board, Mr. Dales, and staff. For the record, my name is Linda Carter, and if I could proffer for the record that we filed an application with this board, all of the information in that application remains true and correct as I literally stand here before you tonight. We also submitted to the board an exhibit book. If I could please move the individual exhibits into evidence. This is a restaurant that has been here at this location since I lived in Old Mill back in 1982. My clients are in the process of finalizing the purchase of it. The only changes that they've made to the business have to do with just renovating it and cleaning it up. No structural changes. And Quinn has been subject to the prior hearings tonight, so she understands she can't do anything without getting permits and without coming to you guys in advance of any kind of structural changes if they wanted to do that. Just for the board's information, even pre-COVID, this place runs about 10% alcohol versus 90% food. Right now, unfortunately, they're doing about 90% carry out. They are not doing carry out of alcohol. They do delivery of food only in a limited area. And that would be our case, Mr. Chairman.
Thank you, Ms. Carter. Mr. Chairman, questions for Ms. Carter?
I have no questions.
Other commissioners, questions for Ms. Carter?
Commissioner Pilkins has no questions.
Commissioner Duffy have no questions.
All right, we'll close the testimonial portion of the hearing and move to deliberation and debate by the board, or deliberation and decision by the board.
Looks good. And I'll move that we grant the transfer.
Commissioner Duffy, I'll second.
All those in favor, say aye.
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 Aye. Motion is carried. Congratulations. Good luck.
Thank you so much. And a special thanks to your staff that, through a very trying time has managed to allow us to file applications and get them before you. So it's greatly appreciated. Thank you. You all have a great evening. And with the board's permission, may I be excused?
You may.
Thank you.
Yes.
Thank you.
Nice seeing
All
you.
right,
Linda.
Next. I'm sorry. Next case is Hysteria Tap House, known as Hysteria Tap House LLC. Ali Gu member and Aaron Lopez member. This is a new license for 3201 Mountain Road, Suite 102, Pasadena, Maryland, 21122. This is a Class D license for beer and wine. They are also requesting entertainment and Sunday permit as well. Anyone wishing to testify, please come forward and raise your right hand. Raise your right hand, please, if you're going to testify. Okay. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth?
We do. We do.
Okay, would you please, you can put your hands down. Would you please state your name and address for the record?
Holly Yu, 3201 Mountain Road, Pasadena, Maryland, 21122.
Thank you.
And Aaron Lopes.
And your address, Ms. Lopez?
Oh, the 3201 Mountain Road, Pasadena.
Okay, thank you.
If you would consider it, would you remove your masks as you identify yourself, please, and put it right back on again if you're okay with that? It's a request.
Hi, Holly Yu. Hysteria Tap House, 3201 Mountain Road, Pasadena, Maryland, 21122.
And Aaron Lopes, Hysteria Tap House, 3201 Mountain Road, Pasadena.
Thank you.
Mr. Burns, did you
All right,
have
Mr.
something to
Burns.
say, sir?
Mr. Burns, the note again, I think you're probably trying to say you don't have audio. Maybe call in using the telephone. Mr. Aronson can give you a phone number to call in.
Hey, Darren, are you getting a message to unmute?
I think he has a problem, Ed.
Yeah, could you log out and then try and log back in? Or either that or you could call the phone number.
Be a little patient here.
I'm sorry, Mr. Deals.
We'll just be a little patient while we wait for Mr. Burns to either call in or re-log in. Mr. Aronson, do you have any insight as to what's going on there? Did he send a message?
I do not, but as soon as he pops in as an attendee, I can promote him to the panelist view. So he did log out, so hopefully by logging back in, he'll have audio as well. There he is.
All right, Mr. Burns, can you hear me, sir? Mr. Burns? We see you. Can you hear us and can you speak? Still have no audio, Ed.
That's correct. Well, give me a minute. I'm going to call him and we can use my phone on that.
All right. I hope that that's not going to cause us feedback, and it might. Mr. Burns, if you have a keyboard, you could use the chat to tell us what's going on from your perspective.
Darren, if you can hear me, can you hear me, Darren? Okay, I did send you the office line. If you can call in. No, I'm not. It's not being blocked.
Might be a problem on maybe a firewall sometimes. Is there a phone number that he can call in directly?
Yeah, yeah. Give me a minute. I'll get it to him.
concerned this might result in some feedback. We've got both dialed in and audio on Mr. Burns' side playing out from the speakers back into the phone.
Then he can turn his speakers off and hear over the phone, can he?
He may try to use his cell phone to join the hearing. What I was saying is he may be able to hear us. Oh, that's right, Mr. Filkins.
Okay, it sounds like you're connected, Mr. Burns. Can you hear us?
He's connecting still. It's in process. There we go.
All right, there he is.
Still connecting. Be patient. There it is. Okay.
Can you guys hear me?
Yep.
You can.
All right. Well, this is going to be interesting. All right. The question is, Mr. Dales, is should I get off of should I just use my phone?
I would think it's best for you to just use your phone. It's not causing any feedback. If you'd like to stay connected to video on your computer, that's fine. But I would say it's unneeded.
Yeah, the only positive is with the computer, I can actually see across the top Mr. Aronson, Mr. Duffy, Mr. Harris, Mr. Maloney, and obviously my client. So let's try this.
All right.
Okay. I was gonna say, if not, you could call my office phone and I could just put you on speaker.
I think it's working just fine. It's a question of whether he keeps video, and that's up to him. And so, Mr. Burns, it's your floor to present your case with testimony or proffer.
Thank you, and I appreciate it. We've been here for 2 hours listening to you all, and my hat's off to the chairman and Mr. Harris and everyone else for getting this done. And I apologize for our technical difficulties after those 2 hours. Very quickly, you have already heard from Ms. Gu and Ms. Lopes, the applicants before you. Very quickly, you should have all the materials that would normally be filed in advance with an application, from their financial forms, their application materials. Their still hearing me, Mr. Dales?
Yes.
All right. Their supporting materials, zoning, et cetera. I supplemented the record as things came in. I think Mr. Aronson and Ms. Gagnon would tell you that as recently as today, we supplemented the record with the trader's license and a few other things. I think the most important thing to keep in mind, the center of this are two people who are going to embark on, and it's a brave thing to do. They're going to embark on having a business that's different than probably any that we have in Anne Arundel County right now. They've described it as sort of a cafe meets a craft brew pub. But the focus is on the meeting place. They would tell you that the idea is to have a place a lot like a cafe where the locals in Pasadena, and this, just so you know, this is between Mountain Road and Disney. I'm sorry, between Edwin Rayner and Disney off Mountain Road. And the idea is to have a spot where folks, families, and others can come, relax, read a book, try a local beer or a local wine, which is also, they've partnered with some local providers. And there's going to be a game area. The point is, especially coming out of COVID, what they conceive is a true local meeting place where there happens to be beer and wine available, but the emphasis on folks getting back together again. They certainly recognize the COVID situation. And while their capacity is, I believe, 65, they are prepared to move forward with, having 32 patrons as long as that's necessary. They're committed to COVID safety and protocols. They'll certainly have masks as needed for anyone who might come to the place and not have one. I think the other thing to keep in mind here is from the contractors who did the build out, which was not insubstantial, they used local companies. They're using local sources for the beers and wine that they have. They're using a local Pasadena food vendor, Wingman, as well as local food trucks to augment what they serve when they serve. And it really is going to be a neighborhood establishment being run by two neighborhood folks. Both Ms. Gu and Ms. Lopes live right there in the neighborhood, and this will be theirs. And hopefully, despite the challenging situation we find ourselves in, it'll be a success. I submit, and I shared this with Mr. Aronson earlier today, and share it with the board. I submit their hours and planned operation details to you. And I apologize, I can't look at the screen and do this, so I'm looking down. They will have weekday hours from 4 to 10 p.m., Saturdays 11 a.m. to 10 p.m., and Sunday 11 to 7 p.m. There will be a manager and 3 bartenders as sort of the normal staffing. They are seeking not only a Class D license for beer and wine, but also, as I mentioned, Sunday sales and entertainment. Entertainment is just simply the ability to have the television screen, which often will run promotions on the craft products that they're selling. So that's the basic background of it. As I mentioned, you have much more in the written record before you. I think you've got 2 excellent embedded locals ready to make a go at it here, and we would ask that you approve their application for this Class D license. Thanks.
Thank you, Mr. Burns. Mr. Chairman, questions for Mr. Burns?
Nope. Just a comment, Hysteria. Sounds like a great name, and wish you well with that. I have no questions.
Commissioners, Wilkins and Duffy.
This Commissioner Duffy, I have no questions.
Commissioner Pilkins doesn't have any questions either.
Okay, so we'll conclude the testimonial portion of the hearing and move to deliberation and a decision by the board.
I make a motion that we grant the license to Hysteria Tap House.
Commissioner
Second.
Pilkins, seconded.
Second, those in favor say aye.
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 Motion carries. Congratulations and good luck.
Thank you. Thank you so much.
Thank you all. Thank you for your time.
Thank you.
All right, bye-bye.
Okay, the next case will be Spazzico Italian Restaurant, KA Spazzico Edgewater LLC, Luigi A. Romano, member and manager, Rosario Lubrano, member. This is a new license. Location is 9 Lee Airport Drive, Suite 100B, Edgewater, Maryland 21037. This license is applying for is a Class H license, beer and wine, multiple, entertainment, restricted to TV privileges only, and Sunday license permit. Anyone wishing to speak for or against, please raise your right hand. Okay, do we have anybody else, Mr. Lyman? Oh, Mr. Romano and Mr. Lubrano.
I believe the applicants should be available by Zoom.
They both just unmuted, but
I'm here. I believe my camera is. Just a second.
okay.
There we go.
All right. Would you please raise your right hand, gentlemen? Thank you. Do you solemnly declare, excuse me, and affirm under the penalty of perjury that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay.
I do.
Please state your name and address for the record.
Luigi Romano, 4921 Idlewild Road, Shadyside, Maryland, 20764.
Thank you.
Rosario Lubrano, 1976, Scott Crossing Way, Annapolis, Maryland.
Thank you.
And good evening again, commissioners and Mr. Chairman and the board staff. My name is Brian, last name Lyman, Lyman, representing the applicants.
All right, Mr. Lyman, you present your case for testimony and proffer.
Thank you, Mr. Dales. We have a application before the board for a Class H license. This is for an existing Italian restaurant located in the Lee Air Park. I would mention, it is in my cover letter, that this is a second location for at least Mr. Romano, who is an owner of the prior location on Baydale Drive, also known as Spazzico. I will, for the record, cite that that's appropriate under the Alcoholic Beverages Article, Section 11, 16073, small Roman numeral 9, because it's within the Edgewater Mayo Commercial District and was designated as a specific commercial zone during the comprehensive rezoning adopted by the County Council, that allows another restaurant license to be held by the same applicants or owners of another establishment that already has a license. That also explains why number 12 on the application is answered in the manner that it is answered, because Mr. Romano and several of the other investors also own the other location on Baydale Drive. With that, I would submit that the applicants are fit and proper persons. All of the information contained in the application remains true and correct as when it was filed. I believe that the complete package has been forwarded onto the board. I thank Mr. Aronson for his help and guidance in obtaining a proper plans. Our paper plans apparently don't get sent to you guys in that large format anymore, and we needed to upload appropriate copies. This is a restaurant that aims to provide excellent Italian food, as it has been for the past year. They opened this location in February, just about a year ago, and unfortunately, they were hit with COVID immediately. The community, I think, has stood by them and supported them. They're running mainly carry-out service at this time, and the hours of operation for both of the locations are going to be Monday through Thursday.
I'm just in pain. I didn't want them to see.
Chief Harris.
I got a bill out in the car.
Wait, Ed and Chief Harris.
Must have lost them.
Hey, guys.
My ass hurt.
Chief Harris.
The hours of operation, sorry, Mr. Dale, sorry, board members. The hours of operation are Monday through Thursday from 11 a.m. until 9 p.m. On Fridays, 11 a.m. till 10 p.m. And on Sundays, it's noon to 9 p.m. If the board has any particular questions about the operation, Mr. Romano spends most of his waking hours away from his home at this location, as I understand it, and is the on-site proprietor. He's familiar with the board's rules and regulations, and we're happy to take any questions for the board. We believe that there is a need in the community for service of alcoholic beverages, nice Pinot Grigio to go with fine Italian cuisine, beer and wine. And I would just note that there is no liquor request here, because that's not part of what their marketing is. They're not going to be a bar. They really are an Italian restaurant and serve beverages mainly with food. They're requesting Sunday service and entertainment for televisions only. With that, I'll submit.
Thank you, Mr. Lyman. Mr. Chairman, do you have questions for Mr. Lyman or the applicants?
I just had one question for Mr. Lebrano. Are you related to Raymond?
No, sir.
No, okay. I won't hold that against you. But no other questions.
We found a different Lebrano, Mr. Chairman.
He was a great restaurateur. Thank you.
Yes, sir, it was.
Yes,
I wish
sir.
I was related to him.
Commissioners Duffy and Pilkins, do you have questions?
Commissioner Pilkins, so which one of you guys is flying the plane in and out of that place on a regular basis?
That would be me, sir.
That'd be you. You fly?
No, I do not.
Oh, okay. Good. You're right by the airport.
Commissioner Duffy, I have no questions.
All right, if there are no other questions from the commissioners, then we'll close the testimonial portion of the hearing and move to deliberation and decision by the board.
I move that we grant the license. Do I hear a second?
Commissioner Duffy, I second the motion.
Second, all those in favor, say aye.
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 Pilkins.
It's granted. Thank you and good luck.
Good luck, gentlemen.
Thank you.
Gentlemen.
Thank you.
Watch those low-flying planes.
Okay, our next case will be Tucker's, known as Tucker's LLC.
Mr.
Preston Blake Senior is a member and Jeffrey Tucker is a member. Our
Wait,
inspect-
Mr. Chairman, can we take a break for about 5 minutes? It's
Yeah.
2 more cases.
Why don't we do that? Unless there's an objection. So moved. We'll take a 5-minute break.
5 minutes. That's all.
See you in 5.
It's 8:15. So 8:20 will start.
20 will start.
Okay.
Can I get you something? Get you drink or?
Yeah, I'm gonna get it.
How's it going? How many more do you have?
We've got 2 new ones that go by quick. Then we have a long one. Been over an hour. 4 hours.
Have you voted on it?
Yeah, no, we extended it.
Oh, geez. So you have to hear it another time?
My fault.
Well, Aaron Burns.
Mr. Tucker, this is Ed Aronson. I have you logged in twice. Can you hear me? I want to make sure there's no feedback when we start.
Hey, Ed, how are you? Can you hear me?
Yeah,
Hold on one
you,
second.
all right, stay right
Yep.
there. I'm going to boot the other one.
Perfect.
Oh, where'd he go?
Oh, you muted him.
Did he leave?
That's what I call really muting them.
Yeah, he was in here
Can you hear
twice.
me?
We can hear you. We can see
Okay.
you.
Good. I know that they're
Here he
all
comes. Okay, good.
in the office.
Can you hear me now?
Yep, you're perfect.
All right, perfect.
All right, just hold tight.
Sure.
Thank you, everyone.
You got 30 seconds, so everybody back? Okay.
Just waiting for Wayne.
And I'm here.
Okay.
Okay.
We're good.
To reiterate part of it, Tucker's, known as Tucker's LLC, Preston Blake Senior Member, Jeffrey Tucker Member, Inspector Roland Marshall. This is a new license for 9001 Fort Smallwood Road, Pasadena, Maryland, 21122. This is a Class D license for beer, wine, and liquor. Entertainment is restricted to TV privileges only and a Sunday license. Anyone wishing to testify, please raise your right hand. Your right hand, sir.
We're off to a great start.
Good start.
There you
Just testing Chief Harris.
He was testing us. That's all. He was testing us.
That's, at least I'm paying attention. Okay. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, please state your name and address for the record, sir.
Jeff Tucker, 8375 Pasadena, Maryland, 21122.
Okay, Mr. Tucker, is there any way you could move closer to your video or,
Yeah, hold on one second.
or turn the light on?
Yeah, yeah.
Okay, that's better. Thank you. Okay, Mr. Davis.
And of course, Commissioner Pilkins always asks to see your faces. If you would do it with, I mean, if you don't want to do it, you don't have to. I'm just requesting that if you can, so the cameras can pick up the faces of the people who are going to be testifying. Thank you. Thank you.
Yep, thank you.
Preston Blake, 8442 Basinius Road, Pasadena, Maryland, 21122.
Thank you very much.
I could just enter into the record that we received several emails for the liquor board testimony, and we received 55 in favor and 1 in opposition, which will be put into the record.
Thank you, Mr. Aronson. And Mr. Fraley, do you want to present the case for the applicant by proffer or by testimony?
We'll proceed by way of proffer. Just for the record, James Praley, P-R-A-L-E-Y, Lessons Praley, McCormick, 7419 Baltimore, Annapolis Boulevard, 21060. I represent the applicants. Before the board tonight is an application for a new Class D license at the request of Tucker's LLC for a new establishment, which is going to be known as Tucker's. This is going to be owned jointly by Jeff Tucker and Preston Blake, and collectively through this presentation, I'll refer to them as the owners, unless of course I need to distinguish between the two. The concept behind this is really the brainchild of Jeff Tucker, who envisions this to be a gathering place for local Pasadenians. This is going to be located in the old Willie D's location, which, as I'm sure the board is aware, has recently been renovated from what was a dilapidated building on the side of Fort Smallwood Road into the building that is there today. The concept behind this is eventually get to the ability to serve 3 meals a day. Mr. Tucker would actually like to do breakfast, lunch, and dinner if the public desires. However, due to the restrictions implemented by Anne Arundel County and the state of Maryland, it's difficult right now to justify being open for 3 meals a day. So at the outset, he plans on offering sandwiches, finger foods, and having food trucks establish residency in the front parking lot. After opening, after COVID-19 restrictions are lifted, the owners are going to reevaluate the business model to determine whether or not there is a significant demand to open a kitchen and serve hot meals daily. But for the meantime, we're going to restrict the food service to finger foods, et cetera, along with local food trucks being outside. Well, this might be Mr. Tucker's first entry into the Maryland restaurant, or excuse me, the Maryland bar industry. He's no stranger. He served as a bartender and a bar manager for over 5 years when he lived in Arizona. And with this particular venture, Mr. Tucker has taken it upon himself to surround himself with several individuals who have been quite frequent folks in the restaurant and bar industry. Specifically, we have Rose Guthrie, who I will introduce a little further down the road, who's going to be the manager of this establishment. As I mentioned, it's located at 9001 Fort Smallwood Road, where the old Willie D's Tavern was located. And that establishment previously held a Class D liquor license. So I would suggest that this board has found a public need for a license in that particular location. Mr. Tucker has been under lease for this location for quite some time, and he has put countless hours and dollars into making this place what it is today and what it will be in the future. What once was really an eyesore to the community and some sort of a dilapidated building has become a very, very nice building. And I believe that the several of the emails address just the state and the quality of the construction that we're seeing today. As Mr. Aronson mentioned at the outset, we've received over 55 letters, or the board has received over 55 letters and emails in support of this venture. And those letters and emails include letters from local and state politicians, local law enforcement individuals, and there's also been an outpouring of support on social media. And the board has also seen the petition of support, which had countless signatures in there as well. Throughout the development of the concept, the owners have reviewed the neighboring restaurants and bars to ensure a limited effect on the business with the local establishments. I understand that the Brass Rail and Twain's Tavern, two of the closest bars in the area, have met Tucker's with open arms and are very excited about them opening. We also haven't heard of any opposition from any of the local establishments. While there are other bars and restaurants in the area, we think that this is a novel concept in that Mr. Tucker hopes to open early once he starts to serve food. We just don't have those types of places in Pasadena, specifically with this particular location. Currently, for hours of operation, those are still a bit up in the air, to be quite honest. We do expect to open from 11 a.m. We would like to have the opportunity to remain open to 2 a.m. However, everybody understands that with the current restrictions, that's an impossibility. We do want to retain the right to stay open to 2 a.m. if the public wants and if restrictions ease. Also, if the need arises and the public's interested in it, Mr. Tucker does intend to open up at 7 a.m. to serve breakfast. He wants it to be a local gathering place, a local meeting place. However, that's still way off in the future, and we're not going to know more there until the COVID-19 restrictions ease a little bit. The owners are very cognizant of the surrounding area. They have made a point of speaking with all of the surrounding neighbors. And as Mr. Aronson mentioned, there was only one letter in opposition to this particular venture. While Mr. Tucker himself does live in Anne Arundel County and has for some time, he doesn't own property to meet the board's requirements and the statutory requirements to serve as the qualifying applicant. So Mr. Blake has stepped in, and Mr. Blake is going to serve generously as the qualifying applicant. He meets all of the board's requirements, including owning property in the county and residing in Anne Arundel County for over 2 years. He's also registered to vote. Mr. Blake is not going to be involved in the day-to-day operation of the business. He does understand the liabilities associated with being on the license. Both he and Mr. Tucker understand that they're equally liable for any infractions or violations which may occur. The owners have received a copy of this board's rules and regulations, and I will tell you, Mr. Tucker was texting me at 7 p.m. last night with questions about them, so he has reviewed them cover to cover for sure. In the beginning, Mr. Tucker, although he does own another local business, plans to be involved in the day-to-day operation of the business. And as I mentioned previously, he's already retained the services of Rose to serve as the primary manager of the establishment. Ms. Guthrie has been in the restaurant and bar industry for over 30 years and has basically done it all. She served as a bartender, a barback, a waitress, a chef, you name it, all locally as well. And since being in the industry, she's never been cited or held or received any violations for the sale of alcoholic beverages. Before you, none of the applicants have been convicted of a felony, nor have they been found guilty of any of this board's rules and regulations. At the outset, again, since we're going to be opening in a limited capacity, we're only expecting to hire 4 staff members. You've already met Ms. Guthrie. There's another manager who's going to be hired by the name of Ashley Berry. And the idea is to hire 2 other individuals who will assist them as general barbacks. The owners have told me that they're going to make sure that all of their employees understand to ask for identification before serving alcoholic beverages. And the firm policy is if you look under 30, you're getting carded. To take it a step further, the owners are purchasing an ID scanner to make sure that that everybody who's carded has their ID scanned to prevent underage drinking. Ms. Guthrie and the other manager, Ms. Berry, have both been TIPS trained. They intend to have all of their staff who are going to serve alcoholic beverages trained as well. And while he is not trained currently, Mr. Tucker has promised me that he is going to receive his TIPS certification before the doors open, and we will submit that documentation to the board as soon as we receive it. As for opening, again, a bit up in the air. Our hopes is that we can finish construction and that Tucker's will be open in late April or early May of 2021. The owners definitely understand the restrictions and the limited operations due to the COVID-19 pandemic and the decreased capacity and seating. And they've indicated that if this board issues the license, they will absolutely abide by the same. Since the submission of the applications and all of the supporting documentation, Really no additions. We do have just a few minor amendments as the board may not be aware. This was kind of a multiple submission application, and I truly appreciate Mr. Aronson and Ms. Hagner working with us on this. There were multiple iterations of the application, which have been amended several times. Right now, the only other amendment that I saw when going through the materials is question 2 on the application itself asks who can serve as the qualifying applicant. Both box 1 and 2 were checked, indicating that both Mr. Blake and Mr. Tucker could serve as the qualifying applicant. That's incorrect. Only Mr. Blake can serve as the qualifying applicant. So we'd ask that that be amended. And also on the financial information forms that were previously submitted, the ownership interest is a bit off. It had Mr. Tucker at 72% and Mr. Blake at 5%. In actuality, to conform with the operating agreement, Mr. Tucker is a 75% owner and Mr. Blake is a 25% owner. So we would just ask that that be amended for the board's record.
Thank you. Mr. Fraley, that's the record has been corrected by your additional testimony and for the clarity of the board members rather than revised. It's just we now have the record set straight by Mr.
Thank you.
Blake.
Thank you. The only other thing is we do understand that while we've applied for the entertainment add-on, that is going to be specifically restricted to the TVs within the facility. There's no intention to have any live music or anything of that nature. So on that, I would proffer that the applicants are fit and proper, and I would ask that this board issue or grant the license, and I'd submit for any questions.
Thank you very much, Mr. Fraley. Mr. Chairman, questions?
Thanks, Mr. Delsey.
This is Chairman. I have no questions. Nice presentation.
Commissioner Pilkins has a question, however. Is there going to be any off-premise sales, off sales from this D license?
Very limited, Commissioner Pilkins. The idea would be if somebody wants to purchase a 6-pack of beer to go, that would be allowed. However, Mr. Tucker does not intend for off sales to be significant.
Thank you very much, Mr. Fraley.
This is Commissioner Duffy. I have no questions.
All right. No further questions for the applicant, and we'll close the testimonial portion of the hearing, move to deliberation and a decision by the board.
I'll make a motion that we approve the license for Tucker's. Do I have a second?
Pilkins, second.
Second. All those in favor say aye.
Aye.
Aye. Motion is carried. Congratulations and good luck.
Thank you very much, Ed and Janet and everybody there. You guys, I understand we were a pain in your butts, but thank you guys so much for your help. Honestly, thank you guys very much.
Thank you very
You
much.
know, you all weren't pains. We know what pains in the butt are. You guys aren't. So
Thanks, guys. Have a great night.
Thank you very much.
Thank you all. Take care.
Take care. Thank you, Mr. Fraley.
Thank you all.
Next
Take care.
Next case, Crofton Eatery, Expectation Restaurant, known as Crofton Eatery LLC. Karen Patel is a member. This is a new license at 2402 Brander Mill Boulevard in Gambrills, Maryland, 21054. It's a Class H license for beer, wine, and liquor, and they're looking for Sunday permit as well. Anyone wishing to speak for and against, please raise your right hand. Okay. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Mr.
Loud voice.
Yes. Okay, thank you. Please state your name and address clearly for the board. Thank you.
Karan Patel, 602 Strawberry Road, Severn, Maryland, 21144.
Okay, thank you. You can put your hand down, sir.
Mr. Bittner, you can present the case for the applicant.
Thank you, and good evening once again, Mr. Chairman, members of the board. May it please the board, I'm Richard Bittner, Bittner, and I represent Karan Patel and Crofton Eatery LLC in this application for a new Class H license. Gentlemen, the license applied for would be located in the Watchapel Town Center at 2402 Brandon Mill Road in Gambrills. It would occupy what had previously been an existing license. It was a restaurant of Middle Eastern fare. It did not sell alcoholic beverages. And based on information that Mr. Patel developed, as well as information from the landlords at 5 Aces Holding, a alcoholic beverage license would be needed for this large 148-seat restaurant to be successful. And they've also indicated that their market studies indicate that it's needed in the community. As I indicated, the license applied for, and before I get to that, let me just do some housekeeping, if I may. I'm going to move in our application and exhibits 1 through 12 that were previously filed with the board, and I ask that they be admitted.
Those are admitted to the record.
Thank you. Mr. Patel, you've examined those filings. You've signed many of them. All the information remains true and correct.
Correct.
Now, Mr. Chairman, members of the board, you can see that what Mr. Patel is attempting to do is to bring a franchise concept, the Eggspectation restaurant, and we've included for your review some background information on the concept, their menu, floor plan, and schematics of what the restaurant would look like. This is a proposed white linen table cloth style restaurant. It's not a fast food restaurant. It's a restaurant that caters to breakfast and brunches primarily, but it has an extensive dinner menu with full American style fare, steaks, chops, seafood, has an extensive dessert menu. You'll notice in the schematic that we submitted 148 seats. That includes a 30-seat private party room that they expect to be able to accommodate retirement, birthdays, that type of thing. We're asking that there be no restriction on the hours. They don't expect that they're going to be open and serving from 6 a.m. to 2 a.m., but they do believe they're going to have some early morning fare. They're going to market. They are a breakfast brunch type venue, so they do expect that they're going to be marketing early in the morning, not before 6 a.m., and that they would be serving Bloody Marys, mimosas, that type of thing. Likewise, they don't anticipate that they would be open late. Mr. Patel is still evolving that. Other egg stations typically close at 10, but again, he does remain optimistic because he has been solicited. He's got a sign up in the establishment, and he gets calls multiple times a day, people who want to come in, people who want to reserve it, people who want to rent it. So he doesn't want to limit the public's ability to hire out his restaurant, use his private dining room at midnight for a retirement party, a special celebration. So we're asking 6 a.m. to 2 a.m. privileges. Mr. Patel, I'll tell you, Mr. Chairman and members of the board, is an entrepreneur, lives in the county. His family are involved in a number of other businesses. And he, living in the neighborhood, saw this opportunity, researched it, saw the Wall Chapel Crofton area is a growing area, an area where the demographics and the spending affordability in the households are much higher than the county and elsewhere in the country. He was aware of the Eggspectation concept. They have a restaurant in Howard County. He began discussions with the principals, and it became a perfect fit. So he's very optimistic that the board will grant him the privileges. You see it's a small bar, 11 seats, mainly for solo diners and those waiting. No entertainment, no dance floor, no music. It's a high-end restaurant that we would submit is needed in the community. You've received a letter from Todd Tang. I'd ask that that be admitted, speaking to the need for a high-end license at this location. Again, I'll reiterate that and proffer to you that Mr. Patel will tell you that on a daily basis, he's receiving 3, 4, 5 calls concerning the restaurant and its anticipated opening. With that, Mr. Chairman, members of the board, I'll submit for any questions.
Thank you very much, Mr. Bittner. Mr. Chairman,
I have no questions.
Commissioners Pilkins and Duffy.
This is Commissioner Duffy. I have no question. I'm just looking forward to dining.
You know what, Otis? Let's go together. I like the idea.
Sound like a winner to me.
And I hear three's the crowd. Is that
You
it?
guys don't have to worry about flying planes in now.
No
I
other
can add
questions?
too, we did get one letter of support that has been entered into the record,
Thank you, Mr. Harrison.
support of approving the license.
Thank you. Nice. It's a nice proffer, Mr. Bittner. Thank you.
Thank you, Commissioner Pilkins.
All right, so we'll close the testimonial portion of the hearing and move to deliberation and a decision by the board.
I move that we approve the license for the Crofton Eatery. And is there a second?
Commissioner Pilkins will second it.
All those in favor say aye.
Aye.
Aye. Motion carried. Congratulations and good luck.
Congratulations and best
Thank
of
you,
luck.
gentlemen.
Thank you.
Thank you. Okay, Karan.
Dance. Yeah, I'm going to come there and dance. That's what.
Yeah.
Oh, wait.
Okay.
Dance.
The next case will be Victory Lounge. This is a request to appear, and it's known as, or address is located at 4584 Mountain Road, Inc. It's Joan Annette Witcher is the treasurer. This is a non-restricted license. This is a request to appear in reference to 4584 Mountain Road, Pasadena, Maryland, 21122. It's a Class D licensed beer, wine, and liquor, dancing and Sunday permits. Okay.
Thank you.
Anyone wishing to testify or against, please raise your right hand. Oh, no, no, that's okay. Okay. Thank you. Please raise your right hand. All right. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth? Ma'am, did you hear me?
You're on mute, Ms. Bittner. Sorry.
Mr. Bittner's, you're muted.
Okay, how about now?
All right. Okay. Did you understand the oath, ma'am?
Yes,
Okay. And please state your name and address for the record.
my name is Angelica Benjamin. My address is 737 Baltimore Annapolis Boulevard, Savannah Park, 21-146.
Okay. Thank you.
All right, this is a request to appear regarding a prior request to renew the license and a transfer that has been approved. So to renew and transfer the license, Mr. Bittner will allow you to present your case as to why the license should be renewed and transferred.
Thank you very much. May it please the board, and I'd like to thank the board for allowing us to appear. As I believe the board is aware, per the discussions with your attorney, this proceeding is without prejudice to my client's pending petition for judicial review that is lodged in the Circuit Court for Anne Arundel County in case number C02 CD 20-001989. That proceeding has been stayed until March the 22nd of this year, pending any possible resolution of this matter that may occur between the parties. This case concerns the transfer of a Class D license that's located on the Pasadena Peninsula at 4584 Mountain Road. The license has been in existence for over 60 years. The project also included the complete gutting, renovation, and rehabilitation of the over 60-year-old building that housed the Class D license that was previously known as Victory Lounge. To say, gentlemen, that this case has had every conceivable trip, turn, stumble, and bumble imaginable, no less of them than COVID-19, would be an understatement. In spite of all that, the Irish pub next door is open. It's open for food sales. All collateral licenses are valid and have been issued. Fire department, health department, zoning, etc., have all approved. My client and the Pasadena community simply await the board's issuance of the previously approved transfer of the alcoholic beverage license. Angela Benjamin was approved as the transferee by the board on November the 13th, 2018. Significantly, on November the 15th, 2019, the board granted an extension to Ms. Benjamin until November the 15th, 2020 to complete construction, and quoting from the board's correspondence of November 15, 2019 to the licensee contained in Exhibit 9, the board directed by November 15, 2020 to have all outstanding obligations taken care of to transfer the license. Thereafter, on September the 1st, 2020, Exhibit 20 of our filings, which for purposes of the record, I'll move and ask be admitted, 23 exhibits in total. Specifically on September the 1st, 2020, Exhibit 20, the board notified my client to pick up the license. My client's having complied with the board's directive of November 15, 2020, providing the board all necessary information and documentation for the issuance of the license. It was only on or about September the 16th of 2020 when Ms. Benjamin phoned the board to make arrangements to pick up her license, which she advised there was no license to pick up. At no time to this date has the board issued any order, directive, memorandum, or any other written documentation indicating as such. We appear today for this hearing after having first made a request to do so back on October the 2nd of last year. I provided, Mr. Chairman and gentlemen, members of the board, this brief synopsis, and now I'd like to, if you would indulge me, to provide you a more detailed chronology of what occurred in this license and why it should be issued, renewed and issued. As indicated, the board approved the transfer on November the 13th, 2018. Thereafter, in a pro se capacity, Ms. Benjamin undertook to complete the renovations, transfer the ancillary licenses, health department, zoning, etc., into her name and open for business. Unfortunately, as I indicated to you, she encountered virtually every roadblock known to a commercial transaction. The contractor, who she knew personally, took her deposit and disappeared, only recently to resurface and complete the work. She suffered a loss in her family. Every repair estimate that she received exceeded the projections and the cost. The roof had to be replaced. The mechanical plant had to be replaced. The kitchen had to be replaced. And all of this occurring superimposed in a pandemic and state of emergency. During April of 2019, Ms. Benjamin re-engaged my services and we began to assist her to finalize the documents. And on April the 29th, 2019, Exhibit 6 in our presentation, we noticed the board of her intent to complete the transfer and the renewal at the same time. The board voiced no opposition to that request. Exhibit 6. Thereafter, license renewal forms were filed with the board and accepted by the board. for license years 2019 and 2020. The board cashed the filing fee payment for the renewal. Exhibits 14 and 15 of our filings. Concurrently with the process, the board no less than 5 times noticed my client that the license was active and pending a renewal. January the 10th, 2020, Exhibit 10. March the 10th, 2020, Exhibit 17. March the 16th, 2020, Exhibit 20, page 3. August 5th, 2020, Exhibit 2, page 1. September 1st, 2020, Exhibit 20, page 1. All correspondence indicating the license was viable, renewable, missing certain documentation, paperwork that has now been received and has in fact been tendered to the board since August the 17th. Exhibits 19 and Exhibit 18. Again, at no time during the course of this proceeding has the board noticed my client in written form that the license has lapsed, that there is no license, that it's void, whatever they claim its position is. The licensee made multiple requests to the board as to what she needed to do to consummate the deal. I direct your references to our solicitations contained in Exhibits 2, 15, 18, and 19, none of which were responded to. Continuing her efforts to consummate the transaction, sales of alcohol occurred on November the 1st, 2019, Exhibit 8, and again on October the 30th, 2020, Exhibit 22. All taxes due on the sales were remitted to the controller. Exhibits 11 and 23. At no time did the board notify any distributors that the license had somehow lapsed, was void, or invalid. At no time did the board notify the controller's office that the license had lapsed, was void, or otherwise invalid. And again, I point out that the establishment is open, selling food. Ms. Benjamin, most respectfully, gentlemen, has acted in good faith in a reasonable commercial manner, relying on the board's communications, moving forward, soliciting the collateral licenses required for the issuance of this license. A process that has resulted in the investment of this family of nearly $500,000. During the entire process, numerous governmental agents, including liquor inspectors, building inspectors, trade, health, fire, and safety inspectors have visited the site. None have voiced any issue with the progress or the means and manners of the transaction and the consummation of the transfer and renewal. No one has ever indicated that the process could not be consummated. The Benjamin family has undertaken, really, in the face of COVID and the condition of the building and the theft of their funds and the death in a family, have faced Herculean efforts to bring what is already been deemed by the board to be a proper transfer for a use that's needed and publicly desired on the Mountain Road Peninsula. Throughout the pandemic, My clients relied on the representation of those agents, communications from the board in moving forward to consummate the transfer. In fact, on September the 1st, 2020, Exhibit 20, the board instructed Ms. Benjamin on how to pick up the license via written communication. At no time prior to September the 1st, when the board issued Exhibit 20 directing the pickup of the license, was Ms. Benjamin notified that there was no license to pick up. In spite of what appears to be the board's contention that a license did not exist, as I mentioned, distributors sold alcoholic beverages 2 times under that license that were then thereafter sold to the public. Accordingly, most respectfully, I suggest, based on the facts of the case, the facts alone of this case, the chronology of the case, the multiple notices from the board as to the license being in existence, the board's acceptance of the renewal applications, that the license is valid and should be issued. We know, Mr. Chairman, members of the board, that this in fact is true and correct, not only on the merits, but via the governor's declaration of a state of emergency. I think it's undisputed, and we would all agree, that an alcoholic beverage license is a state license and it's governed by the governor's state of emergency declarations. When the state of emergency was declared on March the 5th, the license in question was pending a renewal and transfer. And we know this based on the board's own communications to my licensee. Again, I direct your attention specifically to exhibits 2, 6, 10, 17, and 20, where the board noticed Ms. Benjamin that the license was pending. Accordingly, as the governor's state of emergency stayed all state-issued licenses, in effect, what I believe the way to look at this would be, Mr. Chairman, members of the board, that the governor's state, if you think that the board, there's somehow a lapse, that lapse is saved by the state of emergency because the license was still viable to be renewed. I think the proper analysis would be that the license in March of this year was in a state of purgatory. And of course, as we know, purgatory was never designed as a punishment. Purgatory was a holding place where a soul could get itself together, hopefully to move on to heaven. And that's exactly where we are here, I suggest most respectfully. Facing COVID, facing thefts, facing death, Ms. Benjamin persisted. The license would have been renewed, would have been issued, but for COVID in March of 2020. The governor's order, placing it in purgatory, left it there until the board was able to open up, advance cases, the government was able to advance cases, and in August, again, exhibits 18 and 19, August 17th, August 20th, all missing information was provided. The license was elevated from purgatory to the heavens, and it should be issued and should be granted. In all candor, there's no legal reason not to. Nor is there any equitable reason not to. Thank you very much.
Okay, thank you, Mr. Bittner. Mr. Chairman, Obviously, I expect that you will have questions from Mr. Bittner and Commissioners Duffy, Commissioner Token, you will as well. Also, as Mr. Bittner's made his case, and I serve as counsel to you to assess the merits of the legal arguments he's made, I'm here to provide you guidance on any specific questions you have. So remember that as you deliberate and ask questions of Mr. Bittner, and I can provide you my opinion about whether the board may renew this license. So with that, Mr. Chairman, questions from Mr. Bittner.
So your contention is that the license at any time had never expired. Is that correct?
Correct. And we know that most respectfully, the exhibits 14 and 15, which are the renewal applications that were tendered to the board, received by the board, accepted by the board in March. At that point, the record would reflect that collateral traders licenses, certificates of good standing had not yet been tendered to the board.
Correct.
At that point, the renewal applications had been tendered and accepted. At that point, shortly thereafter, March the 16th, the board shut down. State of emergency was declared.
Correct.
So it's nothing that we could do. Ultimately, through due diligence, we provided to the board in August all of the missing information. That prompted the board, I contend, to issue on September the 1st the notice to renew. Ms. Benjamin called the board shortly thereafter, and for the first time was told, no, nothing to renew here. And again, most respectfully, Mr. Chairman, that's superimposed on the other 5 times the board communicated to the licensee, your license is pending. And I'd be happy to reference those again.
No, you don't have to, because I don't have a copy of every one. I do have a copy of the September 1st, which in general is just addressed actually to all of the licensees, including the Victory Lounge. So in addition to that, I believe there was also a notice sent with that basically
March the 16th, that's right.
The March 16th thing. So anyway, my question is back to prior to the COVID. My understanding is that the actual license was never really picked up, the 2019 license.
That's correct. It was not picked up. It was not picked up based on the April 29th correspondence to the board, where I indicated to the board that my client was having difficulty consummating the transfer and that we were desirous of doing the transfer and the renewal all at one time. The board indicated that there was no issue with that. We continued our efforts, ultimately culminating on the tendering of the renewal applications and the ability, but for COVID in March, we would have had the ability to renew and pick up all of the licenses and then transfer them thereafter. That couldn't occur in March because of COVID.
Correct.
And on that note, if I may, Mr. Chairman, on August the 4th, this is Exhibit 2, August the 5th, I received correspondence from Mr. Blumenthal, an email, and I don't think I need to read it in the record. You can review it, but August the 5th, the email, it doesn't reference a particular client. It's a form letter, apparently. But it's asking me to submit information on an unnamed client. I responded to Mr. Blumenthal. I received your email. It doesn't identify the licensee, and I'm summarizing. I believe it deals with Victory Lounge. Tell me what else we need to submit. There's no response. August the 10th, I follow up. Following up on the email, what do we need to do? No response. August the 17th, August the 20th, we provide what we believe are the necessary missing documentations to the board. That generates the September 1st letter from the board, come get your license. So the license, most respectfully, I submit, was in limbo. It was in purgatory, waiting for these things to be finalized, which were delayed because of COVID. And most respectfully, as a matter of law, suspended under the governor's executive order, state of emergency. So as things existed when the state of emergency began, they continue to exist even to this day. Ms. Benjamin has cured any defects, provided everything to the board, is open serving food, and only awaits paying her renewal fee, paying her late fee, because we could see she owes the late fees, and having the license issued. So most respectfully, I submit it's a ministerial function. There's no discretion here. It's a ministerial function.
Okay. I'll withhold any other question at this point.
Commissioners Pilkins or Duffy, do you have questions for Mr. Bittner?
Commissioner Pilkins, I have a couple of questions. In 2019, it appears that that a request someone was notified that the 2019 trader's license was not that the board needed a trader's license for the 2019 year before you can pick up the license, and the license was never picked up. And my question is there in evidence a 2019 trader's license that could have been proffered? And is there a trader's license for 2020?
The answer to both those questions is yes. There is a 2019 trader's license and there is a 2020 trader's license. I believe I may have one moment. That was Exhibit 19 that was forwarded to the board.
What was the date, Mr. Bittner?
They were provided to the board August the 17th, I believe.
Of what year?
August the 20th. August the 20th.
What year?
2020. So here's how that transpired. The board may recall that the seller, the transferor in the license, was an estate. The establishment had actually been closed, inactive because of the death of Mr. Witcher for some period of time and was not actively engaged in business. So therefore, they didn't renew their 2019 trader's license. When I got back into the case and was advised that we needed to have the 2019 to renew, we attempted to get it. That was in March. We couldn't get it because everything was shut down with COVID. We were only able to secure it in August. We forwarded it immediately to the board. So in place is a 2019 trader's license, certificate of good standing from the transferors that comes in under the suspension of time with COVID and the governor's order. Likewise, the 2020 renewal, and this is significant. The renewal applications for both 2019 and 2020 were tendered to the board, accepted by the board. The board received the filing fee for the renewal. Superimposed is the suspension of time in the state of emergency. All of the missing documents I submit would have been provided in March if the government hadn't shut them down. They were provided as soon as possible when they were humanly able to be obtained. That was in August. And then, gentlemen, the board on September the 1st sent a letter, come get your license, pay your fee, come get your license. And most respectfully, To this point, to this date, we have not received any written communication as to why the license isn't being issued. We had to file an appeal. I believe it's 7 different times we requested of the board, what more do you want us to do? And we didn't get an answer.
Well, at this point, it's just a question. I'm still contemplating how these two, and you have in your possession an old or an expired 2019 trader's license.
You have it with the board. It's exhibit 19. Just one second.
Didn't see it.
One moment, if I may, Commissioner Wilkins, I just referenced it and then
It's okay. Take your time.
it was filed under exhibit 18, it's page 2, excuse me, of exhibit 18, following my cover letter to the board of August the 20th, wherein it's addressed to Executive Director Ms. Hagner. I hope you and yours are doing well. Please find and close the following documents for docketing in the above matter. 2019-2020 trader's license, and I can display it to you here. You've had that in, the board has had that in their possession since August of the 20th, I think I said.
But that was a trader's license that we were looking for in 2019.
It's 2019 trader's license, that's correct. That's what was missing to renew 2019.
When did the board have it? When did the board receive it?
August the 20th of 2020.
2020. Okay.
And that was in response to a letter from the board asking for it to renew 2019, because 2019 was still renewable, both because the 2019-2020 license had not yet expired, wouldn't expire till May the 1st. In any event, it could have been renewed. But when the governor put a stoppage on time, none of that matters, I suggest most respectfully, Mr. Pilkins, Commissioner Pilkins, because whatever needed to be provided can be provided under the state of limbo that the governor has created with his executive order.
I really don't want to belabor this, but my dates are giving me a problem here. The board requested on April 29th of 2019 that they needed a copy of the trader's license to renew the license. They never received it. But it didn't, but it does now show up, according to your records, on August the 20th of 2020. So, I mean, if this is just a question I'm asking because I'm confused. It looks like you lost the license because you never responded promptly to the request for the 2020 license.
Most respectfully, I believe that would be an incorrect analysis of the facts.
Wouldn't be the first incorrect analysis I've made, but I need an answer to it because I need to be corrected then. Tell me
sure, and I'd be happy to try to illustrate it for you. So the 2019 application was filed and was pending. Okay, and again, let me go back. When I got back into the case in April of 2019 and found, unfortunately, what had befallen Miss Benjamin, and I realized what we needed to get together, that's when I communicated to the board our intention of trying to accomplish all of this at one time. The board voiced no opposition to that request. Based on that request, and in fact, the board indicated it was okay, and that is Exhibit 2. Thereafter, the renewal application was tendered, the fee was paid, alcohol was sold, the collateral licenses and certificates of good standing were in process of being obtained, and then COVID shut down. So the intent, if without COVID, I suggest most respectfully what would have happened, Commissioner Pilkins, is all of these things would have caught up. The license would have been issued, and the license would have remained in purgatory because there were no active sales. The business was not open, and it wasn't going to open until the Irish pub next door was complete and ready to be open. But yes, they needed to maintain the license viable for renewal. That's why they advised the board that we intended to do the transfer and the renewal at one time when all the paperwork caught up. We followed up on that. COVID stopped that. And again, the board, Commissioner Pilkins, the board noticed my clients 4 separate times. Your license is pending. This is what you need to do. This is what you need to file. And they responded, ultimately culminating in the board sending a letter, September 1st, come get your license. Again, if there was no license in April of 2019, most respectfully, I think it would have been incumbent upon the board to notify Ms. Benjamin and to notify the distributors. No communication from the board went to the controller's office and or to any distributors indicating that the license was lapsed or not valid. And we know that because the Katzif brothers, under the pending license, under the purgatoried inactive license, sold alcoholic beverages under the existing license that were later sold to the public. Taxes remitted, notice to the board, and again, no correspondence from the board, no notice from the board of any impropriety. Ms. Benjamin continued to rely on what was before her, continued to get the work to get the license, get the restaurant open. So there's no subterfuge here. There's no ill will or any desire to try to get around something or get over on anybody.
I only needed a question answered regarding the trader's license. What is the issue date on that your copy? Because I overlooked it. I didn't even see the trader's license in all the massive stuff you sent.
It was issued August the 20th, 2020.
I'm asking about the 2019 trader's license.
That's correct. It was issued August the 20th of 2020. It was issued retroactively.
This subject raises a key issue for the case, and I think I'll provide some legal counsel to the board here. Mr. Bittner talked a lot in his testimony about there being no reason in equity to deny the license, and he provided a lot of, he proffered a lot of argument, and he offered a lot of evidence regarding those cases in equity. All the communication from the board to him, I would say, relates to the equities in this matter. When he says there is no question in law, I would have to disagree. I don't think that Mr. Bittner cited the alcoholic beverages article. And so I'll direct your attention to 4-11, which says that licenses expire on April 30th, unless otherwise provided by the article. So it is actually my opinion, surprisingly, I think from what I've just said, that the board may renew this license. And what I would direct the board's attention to is 4402, which is the section of the code about eligibility for renewal. And I think there is some room, some requirements you need for you to administer and interpret your own laws. The laws that govern your board is what I mean by that. And I think that you might, knowing that I believe that legally you can renew this license, But in asking Mr. Bittner these questions, Commissioner Pilkins, regarding why the license did not expire on April 30th, 2019, I think the questions that you should perhaps seek answers from Mr. Bittner is that relate to whether or not the license was eligible and whether it was in fact renewed and then not issued, but it was in fact renewed and not issued because the trader's license wasn't provided. Again, it's my view that you legally can renew this license, but I would suggest that you ask the questions about those sections of the code, 4211 on expiration and 4402 on the eligibility for renewal.
I only needed a question answered about the Victory Lounge for 2019's trader's license. And that's really all I asked. I was curious about that because why didn't it get sent in on the 29th of April, 2019? That was my question.
Thank you, Commissioner Pilkins. I understood that was your question. The relevance to that question hinges on whether the license was renewed, and that document you're referring to is a key question in answering that. And so I think that whether or not the license was renewed under 4402 is the key question. And again, you could interpret that it was. And Mr. Bittner may have an argument on that, or he may not. But my advice to you is to ask him to relate to that article, those sections in the alcoholic beverages zone.
So moved. I mean,
Commissioner Pilkins.
Commissioner Pilkins is on mute. I didn't hear anything.
he may not have said anything.
I was, yeah, I'm here. I just don't have that in front of me. So that's why I can't ask the question, because unless you're instructing me to ask those questions, then I will.
I've advised it might be a good idea. You have my legal opinion that you legally can renew this license. I don't think that you must, depends on your interpretation.
I'm fine with that. I just needed to know why that, never mind. I'm not going to, I'm looking for a reason why this whole thing occurred. And it's just beyond me that we're here doing this at this hour. So anyway, thank you for accommodating me, Mr. Bittner.
I thank the board for allowing us to try to clarify this, and if I may try to respond to that last comment as to how we arrived here. I think sadly we arrived here because Miss Benjamin, after the license was approved, was victimized by fraud, suffered a loss, the death in her family of her mother-in-law. Again, every estimate on the building was wrong. And sadly, she became overwhelmed. In April of 2019, we noticed the board about these problems, and we indicated that we were trying to get everything together and we would do it all in one swell swoop. Unfortunately, that didn't happen. It didn't happen because of any malfeasance on the part of the board or any neglect on the part of Miss Benjamin. It was just an overwhelming situation that Miss Benjamin relied on the communications of the board to go forward. And clearly we would be in a much different situation if the facts were different. But again, I'm not going to reiterate them because I think they speak for themselves, that this license is viable.
Thank you again.
Phil, if you could give us some clarification about 4402. I mean, is
sure. So 4211 is the problem for a license that says that all licenses expire on April 30th unless otherwise provided. If you go to the renewal section and you go to 4402, it says that licenses that talks about which ones are eligible for renewal, and the eligibility is for licenses that are expiring. And this license was expiring when the renewal was submitted, and then the communications from the board indicated that the renewal had been granted but couldn't be issued. So it's still expiring, and so therefore it's still eligible for renewal. It would be a problem if the license had not been renewed and no information had been requested. Then it would have expired on April 30th, 2019. The board can interpret its own governing rules here to determine that the license was renewed and not issued, or is still expiring and not expired as it's provided in 4.2.11. So I think if you take that interpretation here, then that prevents the lapse of the license, the loss of the license in 4.2.11 in 2019, and the governor's executive order allows it to be told in this year.
Okay. Question for Ms. Hagner?
Mr. Chairman, was that a question as to?
No, I had a question. Is she available for questions?
Yes, sir.
I was just wondering how many other licenses we have in purgatory.
From 2019 or 2020?
19. I'm just, it's kind of facetious. I mean, is it something that?
We don't have any more.
Okay.
They either were issued or they died. And because we had no trader's license for 2019 and it wasn't issued to 2020 because there were taxes due, that's why the license expired. And how can you purchase alcohol when you don't have a liquor license? This is the last time this license was renewed for this establishment was in 2018. And COVID didn't hit until March 2020.
Correct. Thank you.
I may just briefly, Ms. Hagner is 100% correct. The distributor cannot sell alcoholic beverages unless there's a license. There
And
was a
Mr. Bittner,
license.
we have the
That's
sheet.
why they said there was a license. That's why the distributor sold.
Sir, I have a sheet that was sent to each distributor, giving them the names of all of the establishments that had not picked up their license and could not purchase any alcohol.
Ma'am, I can't speak to that. I've never seen that document. No notice was sent to us indicating that, and Katz's brothers disregarded that notice on two separate occasions. I'm not disputing that it was sent, but
And as far as the documents being submitted, Miss Benjamin kept calling and saying, I need to get my license. I need to get my license transfer. And we told her what was missing for the transfer. And then she changed her trade name, and then she formed an LLC. And I specifically told you that she had to go back for another hearing to change it over to the LLC. And I told her on a Zoom meeting the same thing.
Hey.
I'm glad I asked that question now.
And one of the comments you made, Mr. Bittner, in one of your correspondence, this board or none of the boards are in the business to put people out of business.
We've got to address comments to the board, and the board can ask questions, Mr. Bittner.
I'm sorry.
It's okay.
I just think it's a bridge too far. It really is. That's I'm gathering my opinions, and maybe I can be dissuaded on them, but it's just too many things. And we do have the rules and the law to look at, and sometimes they're conflicting. And sometimes people do make errors, but it's just a lot of mistakes have happened on this particular license. And I'm still.
Which goes back, my only comment to that would be that argument, I think, would be persuadable, but for the board's noticing the licensee of the eligibility of the license. If that were correct, if the board viewed this license as dead, why did they send a notice telling Ms. Benjamin to pick it up? Why, on 5 separate occasions, did the board notice Ms. Benjamin that the license needed this, that, or the other thing? If you're correct in your analysis, and most respectfully, I believe you're not, then the board should have generated a letter in April of 2019 and May the 2nd of 2019. Your license is done, you're dead. They didn't do that. They accepted the renewals thereafter. They cashed the checks thereafter. They received the notice of alcoholic sales and did not tender an objection. And that created, most respectfully, a detrimental reliance on the part of Ms. Benjamin to go forward. And it would simply not be proper, most respectfully, for now, after sending these notices, then paying the fines, for the board to say the license didn't exist. It just is not correct, most respectfully, as a matter of law, given the conduct of the board.
Well, one of the things that I also, I mean, don't know how to put this in words, but now the licensee has changed to another owner, or become an LLC, and then it was tried to move.
No, the licensee is Ms. Benjamin. That, if I may, I think that's what Ms. Hagner alluded to. After the transfer was approved, Ms. Benjamin on her own attempted to get the other necessary documents. And when she applied for the trader's license, the occupancy permit, etc., she applied in the name of an LLC that she intended to create and transfer the license to in the future. She didn't understand Ms. Hagner's correct recitation of the rule that the license had to be issued in her name, because that's what she applied for, in her name. So and then superimposed on that, unfortunately, is she's a victim of fraud from the contractor, et cetera, as I've alluded to.
Well, I'm going to stop asking questions, but I'm going to sit here and ponder what I've learned. And I'm sorry I ended up dominating this thing. I just had a couple of questions about it, and it just it's gotten so complicated that I'm a little at a loss at this point to know exactly what to do. So I'm going to back off and click my button here and let somebody else work on this problem.
There is no doubt this is a complicated and unusual question legally, and COVID is probably the biggest, the most unusual component of this. Really, what we have to ask, because of the COVID year that we've had, is whether the license expired in 2019. And so whatever your decision, however you deliberate, I think you need to make clear, I suppose mostly in the case, if you choose to deny it, you need to make very clear for what reasons you believe that to have expired and not be capable of renewal and transfer. It's my advice to the board members as they deliberate and make their decision. If you decide, on my advice, that it can be legally renewed and transferred, I don't know that the same level of concern exists for spelling out your rationale. But that's my advice, is whatever you choose to do, if you're going to deny, then explain why. So we could issue it in a written opinion.
I understand. Thank you.
Oh. Well, I'm going to throw out some thoughts here. It's a pretty interesting, to say the least, situation we find ourselves in. There's obviously a lot of moving parts, and it looks like there's some miscommunication. It looks like the owner had some tough times with regard to trying to get this restaurant off the ground, and ran into a lot of fraud on the way, cost her a lot of money. And I think she definitely obviously wants a license, and it appears that she qualifies for one. You take two avenues at this point. One would be to consider the license dead, as we normally do with dead licenses. You go and apply for a new license. Or we look at this and say, maybe the license was expiring, perhaps, in a sense that it may be a way to get the license that she's looking for. So either way, she's going to go that way, or she's going to get a new permit and a new license application and go that direction. So I'm just throwing some thoughts out there. You know, it's unfortunate that we're in this situation, and I'm going to think about it.
May I?
Yeah.
Chairman, option number one of reapplying for a new license, I don't believe is viable here. The license is located on a non-conforming use. Aside from that issue, a church has located within 1,000 feet. So I don't think that's an option.
Thank you. Well, so I guess we have just the one option. Is that it, Mr. Bittner?
I believe so, Mr. Chairman. And as I indicated, I agree with Mr. Dales in this regard, that what we have here is an expiring license. And an expiring license can be revived. It's not expired. It did not expire. And most respectfully, we know that because the board never said so.
Well, I think it's in the law when it does expire, correct?
Yeah,
unless it's expiring and you're attempting to renew it under 411, which is what was going on here.
To be clear, the license was expiring in 2019 when the information was requested, but it was potentially, arguably by Mr. Bittner, that it was renewed, and then again immediately expiring because he hadn't provided the trader's license and picked it up. However, it could have been renewed and not issued, and therefore still expiring. And with all candor, it would have expired for sure in 2020 were it not for the executive orders and the pandemic tolling. So, but for two strange circumstances that come together in this case, that there was additional information requested and not provided, so you have an expiring license, and then you have the pandemic. We won't find ourselves in this situation often, but I think those are the two strange factors that come together here, that if you choose to interpret the license as expiring, you don't have to, but you can, I think, allow for renewal.
Well, I'll add one more piece of information that I come up with is this license was dead after the 2019 period. That's how I'm viewing it. And it didn't have to, it just did. And all we needed to do was submit the 2019 trader's license. And I think that license would have been issued. That's what I think. And it wasn't. Then they would be renewing this license if they still qualified for it because of the non-conforming use and the church that's being relocated nearby. That's prevented them. So this applicant is back now trying to patch up this problem that began in 2019. That's what I'm seeing. So the word expiring doesn't work for me, trying to get them back into a license. I'm only one vote, and I've clearly stated how I feel about this based on the facts that I've heard, and I've made that decision, but no one's been able to change my position on this yet.
Oh, well. Okay. Anybody have any comments before I make a motion.
Yes, this is Commissioner Duffy. I just have one question in reference to Mr. Bender testimony and everything. Am I hearing you correct to say that between January the 10th, your exhibition 10, as well as today date, that everything would have been resolved if it had not been for the county executive order?
Commissioner Duffy, if I understand your question, yes, that's correct. When this all came to a head in March and we had some communication about missing documents from the board, I can reference the exhibit number in just a moment. We were in the process of providing that, or we would have provided the trader's license, etc. But everything was frozen, everything stopped. We weren't able to get those documents until August. And August the 17th and August the 20th, in response to the board's request for additional information, after filing the renewal forms with the board and having the board accepting the filing fee and cashing the check, we submitted the missing documentation, including the 2019 trader's license, certificate of good standing for the transferee, which, remember, gentlemen, was an estate. So part of the issue with obtaining the 2019 trader's license was that the transferor was not actively engaged in the sale of alcoholic beverages. So they didn't need to renew those. They were waiting for the transfer. In August, once things began to open up, we provided to the board, as soon as we could get it from the controller's office and assessment and tax and the county, all of the missing documents. That prompted the board to issue the letter September 1st, come pick up your license.
Right, we talking about exhibit 20 and exhibit 10. Exhibit 20 is the first 1 September letter, and exhibit 10 is the notification in reference to the letter that you received from the office.
That's two of the letters.
Yeah, two of the letters. And those are the two that I'm focusing upon. Thank you.
Yeah, Mr. Bittner, Chairman here. It doesn't say come and pick up your license. I mean, on the September 1st, 2020, it's pretty much a form letter outlining ways to pick up your license if it's there. There was also a notice that your application for renewal is not in order that went along with that. So, you know, there's a lot of moving parts here. And basically, the person who's getting hurt the most is Miss Benjamin. And she's sitting right next to you, you know, praying, I think, hoping that she gets to heaven.
I think she is, Mr. Chairman.
It's what?
I think she is praying.
Yeah.
Not that she should be, but I mean, she's the one that's getting hurt here the most. And it's not right, in my opinion. So I'm going forward to make a motion that we, in the spirit, if you say the spirit of extending or renewing, if that's an option that we can look at, that we extend this license and we renew it. So I hope that's the proper lingo, but if not, that's my intent or what I'm trying to do here. So,
Mr. Chairman, just for clarity and making the motion language right, I think this is a request to
transfer and a referral.
Yep, to renew and transfer the license. So that would be the motion.
Right.
Okay, to renew and transfer the license. I make that.
A second.
Okay, we have a second. Is there any further discussion on the motion? Seeing none, call the roll. Those in favor?
Aye.
Aye,
Wilkins, aye.
it's carried.
Thank you, Mr. Bittner, very
would
much for
say,
your patience and your time and your explanation.
I would,
No, gentlemen, we thank you. We cannot thank you. My client, I don't know if you can see it now, she's crying virtually hysterically. And
well, let's hope.
I may start, so thank you. Thank you.
Mr. Bittner, nice job. Thank you very much.
Thank you, Commissioner. I always enjoy the banter.
And
But it is sometimes.
Mr. Dale, I want to thank you for your explanation and being right there for us in reference to 402.
Thank you.
So I did take out my book and read my book.
Congratulations, guys.
Okay.
Thank you very much.
Right there.
Ms. Benjamin, good luck to you.
He said good luck to you.
Thank you.
You're welcome.
Thank you so much.
You're welcome. And good luck to you.
You all be safe. Thank you. I'm sorry. We'll receive the proper paperwork. We'll dismiss that appeal.
I couldn't hear that. I'm sorry.
He said he
We'll
was.
be dismissing our appeal, our petition for judicial
Wonderful.
review in light of the rules.
That'll save you some money. Great.
Could we be excused?
You may.
Thank you.
My wife just put my pillow and bed sheets in the den here where I'm working.
I see you.
I'm facing the same thing, Commissioner. It's the same thing.
Nice job, Phil. Thank you very much.
The
Yeah.
beauty is that you don't have to drive home now. You know?
Yeah. You know, sometimes I drive home. You don't go directly home. But
Oh, yes. All
yeah,
right. We'll leave that at
don't
that.
do that anymore.
Okay, is there any other comments? Anybody want to say anything at this point? I think glad it's over.
Well, you know, John, you did the right thing. You really did. And
We're still on the record, just don't forget that.
I know, but it was a very difficult decision to make. And I worked very hard to try and understand this thing, to find something of substance to put together on this. So I'll stop my comments now, but we worked hard on this one. So.
Okay, no other comments. I'll make a motion to adjourn.
Bless you, my son.
How about a second? Do we need a second?
Second, yes,
It
Commissioner.
is. Okay.
Yeah.
You want to get tucked in there, John? All right.
There's a sofa here, but I think she'll let me out if I bang on the door enough.
Gotcha. Okay, everyone.
John, thank you, Otis.
Have a good one.
Bye,
Thank
all.
you.
Wayne and Ed still with us. Whew. Judy left, I guess. Yeah. Good night, everybody.
Good night.